made in writing in respect of any contravention of this act and report to the register. Institute prosecutions under the orders of the Executive Committee of the state. Exercise such other powers as may be necessary for carrying out the purpose of 3, 4, and 5 of this part, or any rules made therein under. Now let us see the power of the inspector out here under the Drugs and Cosmetics Act. Inspect any premises where any drugs or cosmetics is being manufactured and means employed for standardizing the testing the drugs or cosmetics. Any premises where any drugs or cosmetics is to be sold or stocked or exhibited or offered for sale or so and so. Take sample of any drugs which have been manufactured in so and so from any person in so and so. At all regional life with such assistance, if any, he may search any person who has reasons to believe has secreted, enter any person, stop to search any vehicle, and order in writing in so and so. Examine any record, register, document, or materials with which so and so. Require any person to produce any records, registers for manufacturing. And where is the power of you to check whether that premises is there or not as a recognized license? So many. You are saving the money of whom? Them. Commissary Council does it, you have to only give the approval. But if you don't frame the rules, how will they appoint? Tomorrow they appoint somebody, you are going to come up with one thing. Then look here, we have not given the qualification. They are not qualified. Because the qualification has to be set by you. And madam, you have asked for the qualifications for the framing of the rules. Because it's the state who can frame the rules. No. Now tell me, without the qualifications, what is required? How do you appoint somebody?
When they give the, if they consent to the demands like clearance made by us to let us appoint the inspector. Okay.
Madam, how will they appoint? Now, how will they give you an approval without the qualifications?
Okay,
Then, so unless you go ahead with 46 without the framing of the rules, because otherwise the other things is okay, powers are given. But what is the qualification of an inspector? So unless they don't do that, how do you pursue? How do you appoint somebody?
Unless and until they give the approval first of all, that we can appoint.
Madam, have you taken this point about 46? They have not made the rules.
Then of course,
You do one thing, you bring it by way of an additional affidavit. Then what happens? This court can pass an order to the effect for them to frame some rules. Because otherwise the provisions of the Pharmacy Act cannot be taken note of. And the moment this court says that this inspector of drugs cannot investigate as regards the licenses, then they will wake up. Don't you think so? Then only you will get the power.
we have otherwise referred to policy 7F, but
No. Unless that rules are not framed, you can't appoint. So for appointing, you require this. Otherwise, the provisions of the Pharmacy Act is not there, which is the mandate of law. You take that ground that for giving a proper effect to 26A, it is required that they frame the rules. And without the rules being framed, This court, we can't, because the other aspects are different, but the rules, so they can come up with some executive order in the meantime, framing, prior to framing. So thereby you can appoint. So then only this court can give a direction for them to appoint, do something, but otherwise the Pharmacy Act, which are the consequences which will befall upon the people. Without framing that, you can't. So 26A cannot be given effect to unless 46A rules are framed. But how do you appoint? Because you have no power to set the qualifications. If you had the power to set the qualification, it was no problem at all for 26A being given effect. You are coming out here on the ground that the government is not giving an approval. That is another aspect of the matter. But how do you appoint somebody?
So maybe under the, once the approval, they give the.
No, approval.
Along with.
Approval for that, are you not going to have an advertisement for appointment? You are, because they will be public servants. Remember, in view of 46.3, 46.4, they'll be public servants. So you have to come up with an advertisement. So in the advertisement, what is the qualification you are going to put? Class 4. What? Unless that is not done, 26A can't be given the approval which you are seeking. How do you implement?
Change required. For example, 42. For that has come into force. For implementation of 42, also 26A is required.
Understood. So all these things,
These are
this court has to pass an order saying when you come up with such pleading, this court has to come up with an order, and as such, pleading should also contain that this Pharmacy Act, in view of specific mandate given under this, and Section 22 does not permit the drug inspectors for the purpose of making inspections to know as to whether the person who is engaged in compounding or dispensing is a registered pharmacist or not.
That rules are yet to be framed. That aspect is not.
How do you? So therefore, you have to give this court a handle by which this court can pass an order that unless and until you don't appoint, the provisions of the Pharmacy Act cannot be as regards inspection for the purpose of finding out who is engaged in compounding, investigate complaint, and the drugs, inspect any premises where drugs are compounded or dispensed, and submit a written report to the racer. That is okay, but the main power is 26A to B. You take away this power, then they will do something. So you give me a handle for that. Then only this could be. Because if they don't bring the rules, you can't appoint. And if you can't appoint, the approval will come later on. But you have to issue an advertisement first. Ms. Deep Borgohain, the learned counsel appearing on behalf of the petitioner, submits that she would like to file an additional affidavit bringing on record additional pleadings. Bringing on record additional pleadings as regards non-compliance to Section 46(2)(FF) of the Pharmacy Act 1948 and the consequences thereof. List the matter after the vacations. Next week, we are running out of time now. Because you file it. List the matter on, I'll fix it after the vacations because we'll have it on 14th of November. List the matter on 14th of November. The said additional affidavit be filed by 17th of by 13th October, you can file it. By 13th October, the petitioner, the respondents shall be at liberty to file their reply to the said affidavit. additional affidavit if so filed by 7th of November. Then only with that, this court can take it up. And third, I always enter to all matters. No. Partners, no. Not necessary. But this matter, if it comes to me, this is the only way. Because otherwise, by this only you can catch hold of it. Otherwise, they are not going to do anything. And if you think about it, you may think about also putting an additional prayer also. That they cannot inspect in terms of 26A2B with those inspectors. Just put that ground in your additional affidavit that they cannot inspect or exercise powers under 26A2B. That is enough. Have you mentioned that? That these people cannot inspect under 26A2B? Very well. If that is there, it is okay.
And number 2-4, order.
Huh?
For 4, my lord, I have additional income that has facing problems. So now I ask my client to bring it to something they want to know.
No, I have asked you for the exploring. This is the SS road one.
Yeah, I am for the
You are for a petitioner. And you have been given some place where you are having 225.
250 members, what's it?
And they have given you a space for?
I mean, the mezzanine floors usually do not have the ceilings are too low. Firstly, these people have to remain in a constant unnatural posture first if they enter. And the space is not sufficient, my lord, for moving.
Now, but Mr. Sharma, you have to also acknowledge. Now you are under a shade.
No, that is not no. But the most relevant aspect, Lordship, that particular space already stood allotted for the.
That we are concerned, we'll take care of that. But you have been given that space where you have a shade and they are willing to, you are not willing to go there.
No.
You are willing to go there.
No, my lord, then we are praying his lordship appoints a commission to inspect it.
Why?
To give a report as to whether the place is convenient enough to accommodate 250%, whether it is convenient to run the business as contemplated under Schedule A of the 2014 Act, which says, lordship, if these vendors are to be relocated, they are to be relocated in a manner that they can carry on their business in a manner in which they keep earlier, I mean,
that I don't think the act can be so unreasonable.
Schedule A specifies.
You see, Schedule A will be only guidelines.
No, Lord, there's a.
Show me which provisions you are referring to.
Schedule A to the act. First.
Schedule A is not there, first schedule is.
First schedule. And you see the conditions which.
Let us first see section 21. Plan for street vending. Every local authority shall, in consultation with the planning authority and on recommendation of the town vending committee, once in every year prepare a plan to promote the vocation of street vendors covering the matter contained in the first schedule. The plan for street vending prepared by the local authority shall be submitted to the appropriate government for approval, and that the government shall, before notifying the plan, determine the norms applicable to the street vendors. Yes. But that these 21 is only for the purpose of those people for whom there will be a plan. But we are concerned about a relocation.
misunderstanding. Yes, honorable division bench very correctly directed that they be relocated within 3 months.
Hmm.
But those have to be done in conformity with the guidelines laid down. Those have to be convenient for the more than 250% that you are relocating. Can you just identify your place, my lord? I mean, had these sites been placed?
No, but Mr. Sharma, have also to say as to how do you say, what right do you have to make a street bend? What is your right?
Because those were unrestricted, because prior to-
Where did you have a trade license at that point?
Yes, we were, Lordship, we have, we have been paying them, taxes every day, taxes used to be collected by the municipal authorities, so.
No. Do you have
No,
trade
no.
licenses?
Trade licenses, of course, for the street vending was not there, but Lordship, we.
So did you have a vendor's I card?
Many of them, yes.
How many you had there? How many had any license or any authority from the GMC to vend out there in SS?
Because Lordship, that is taken care of by Annexure 1, page 21.
Of?
Which is the certificate of registration. of
Annexure
society.
1, page 21 of
My
repetition.
repetition, Lordship, 3749.
3749. 3749 from which? 3749. Yes, show me. Annexure?
Annexure 1, Lordship, page 21 of 3749. Which is because we registered.
Oh,
after-
registration, that you may do it, your thing you keep on increasing by yourself.
Annexure,
What authority did that? You want to impose upon the state to give you a relocation of a particular area. And if that be so, you have to show that these are the people who have been authorized by the GMC. Otherwise, it will be innumerable people. A person out there at just in front of Bhangadar Medical College will come out there and also do that.
and Lordship, that is also admitted by the CMC in their communications prior to setting us, my lord. Page 42, Annexure 8.
Page 42. This is in reference to the Honorable High Court's order dated so and so, as is occurs here. The mezzanine floor of the multi-story GMC complex have been made ready for your occupation as per the High Court's order.
Then next, Lordship.
No, that is okay.
Yes.
So that association has been given, allotted the mezzanine floor.
Yes.
You are agreed with that the mezzanine floor is not proper for you to.
That is our only grievance, and that is our sole grievance. On top of it, my lord, that is allotted to someone else.
No, that allotment, as they have given it, they will give it to you. Don't worry with that. This, when they have given an undertaking and there is an order passed by this court, where is that order? 1458. 1458. In the interim, it is provided the respondent shall not take any course of measures. Where is the order of here? Are intended to be shifted to the mezzanine floor belonging to the GMC. Now, there is any order in the PIL? Where is it?
Number 38.
And PA. It's a division bench or a single bench?
Division bench.
So many orders. What is it? The apparent vendors are occupying a major portion of the room in public purpose. Combine upon the resident to provide suitable vending zone to the vendors by implementing the act in the true spirit. It appears that the act has been duly notified and survey has been done, and as such, there is no reason why the vending zone should not be notified and the vendors are not provided with suitable place to run their trades. In view of the above, it is directed that the government shall pass necessary orders within 3 months from today specifying the vending zones as indicated above by implementing the end in a year. Till such notification is public, the vendors shall not be evicted without following the procedure. However, the BA is directed to take appropriate measures for maintaining safety of the public at large, commuters and so on. So the chief, so the division bench has done everything, given you everything.
They are also given in the result.
Huh?
They are also given in the result.
Given everything. Now the thing is,
Because
you have given the mezzanine floor.
the division means
What are your business? What business do you do?
ready-made garments, basically small daily items. Purchase.
So these are all ready-made garments.
Ready-made garments.
And what is the height of the mezzanine floor?
Mezzanine floors usually lodging, but not more than 7 or.
No, usually no. You have to come before this court and say in
So that,
specific.
we can maybe
Yeah, are we saying that this matter is so long pending and you don't know, you have been quarreling out here that you have to, you cannot bend properly out there in the baseline floor because of the height and you don't know the height?
not more than 8.5, 9 feet.
9 feet is good enough.
Good enough, but my lord,
You want the AC?
because lord, if we were there in the farm in the rain, I mean, the thing is, division means has correctly observed that they should be accommodated, but there is a specific observation that to provide suitable bending zone. That is what we are.
The
on.
bending zone they have given you in the baseline floor. Now tell me, you are an association.
Lord,
If you are an association, you have a members list. Where is the members list?
let us submit, Lord. We have
And what is the, how many members were there when they offered you the baseline floor?
we were lots of.
And what is the area of the Medland floor, Mr. Bora? That is the entire issue going on here. As to give it to them, he is saying that this is not proper. Nobody knows anything. I think both all the petitioners and the respondents wants a status quo be maintained in the present manner till another 15 years, I suppose. It's you don't know. It's a long matter. He's all along complaining that this is the area is less. We are 250. If you put the question to him as to what was the, how many bedline floors were there, how many persons were there at that point of time? No, not. Was it 230 as on the date on which you allotted? And they have not increased thereafter.
That I don't know, but they are very good.
230. So 230 members were there. So this area is how much? And how much is the square feet each person is going to get? And the mezzanine floor is empty now. So you find out and you tell us, in fact, this aspect should have been more clear for you. I could have disposed it of directing them to give it, because if it is 9 feet is the height, then it's a fair height for any business. Because you normally you don't have so much of height. Yes, this height I think usually be 9 feet from here down below this portion, not here. That portion is 9. That is 9 feet. So 9 feet is fair enough. No, 11 is this. 11, 12. 12 is this. That will be 9. Maximum it will be 10. Nothing more than that. And the Mizoram High Court has only 9 feet for the judge, 8 feet for the judge. After standing on this podium, there is a chance the fan may hit with the new building.
What is the issue with the number of vendors? And then my lord, in that any point of the needs of the vendors have, at least 3 customers, whether the first place can accommodate. Firstly,
No.
vendors that Mr. Bora is saying.
First of all, for Mr. Sharma, first of all, you have to also appreciate that there is a shade which you are having.
Yes, my lord.
These
Of
vendors
course.
never had any shade. They used to work out there in the hot sun out there with a tin roof. There's nothing else. Now you have a shade. Now, once you have got a shade, now the question is, how much is the area?
Yes, lord.
How much? Now, why you are asking him? You know that you have been going there.
No, we in fact were not even properly allowed to go inside because there's been occupation by this.
No, it is empty. Because Bora, it's empty.
Yes, it's empty, but
No, forget about them. They have given the allotment to you. So now, under such circumstances, it is yours. Now, the question is only formalizing and finishing this matter off.
yes, sir.
When can you get it, Mr. Bora? We'll have it the next, today is Tuesday, no? On Thursday.
Yes, sir.
Get this thing done, because then only this Medland flow goes to him. And who are they?
That the original is traders, because GMC has gone on a very municipality, then after the mind of this parents came to place, we lost our place of business. The Samaratam got interfered and says that accommodate them. Now, they take 17 years to construct the building. Now, what they have done, they have given us an inconvenience place, it's a method for the speech traders.
Medland flow.
Yes.
It is not-
Nobody wants to go there.
You have given it to them also.
Then allocate the method and go. And as allocate, there is not a single speech tender and method.
You are fish vendor.
Feel better. Yes, but
And down below is what?
the ground floor is given, that is direction of this.
No, ground floor is what?
Now, somebody is occupied many, well, classroom.
Now, what is the business in the ground floor?
Ground floor, there are no study. Study there. And vegetables, I don't get, there are not single fish vendor. I don't, they were allotted,
You are who? Which writ petition?
this is the 183.
I have one also.
Okay. Allah, allotment letters are, that's why it is honorable for directed to the give this allotment letters, I have brought it because I cannot bring it to the record. It's me.
NC Bazaar Municipal Market
Dealers.
Dealers Association. How many are your members?
This is as per allotment by the page.
No, forget about that. You are an association. How many members you are having?
55 is the, we are.
55.
Page 24, and it's a D, madam, this is the allotment.
So you send, allot them nearby that place, near that National Public School, where you have that drive. Not Pamuk. The other one, nearby that, what do you call, wholesale, wholesale, allot them there.
My head, there were 55 of them were allotted, all of them are continuing. So, there is, these are my affiliates, then I have 5 on 27, 29, 7.
Yes, tell me.
In page number 2. there is a
When-
column,
27, 2018,
722.
in which matter?
In 180.
29/7, 2022.
Page number 2, what you see the column minus, they have made a column, is vendor deal. Not a single vendor.
That the number of fish vendors at the ground floor of the fancy bazaar is fish vendor nil, egg vendor 2.
They were initially appointed, they allotted.
So, what do these people do?
They are not limited with them. No other.
Let us see where, here, at the, here is saying, is a registered association of a juristic person and its so and so area. They state that the common voice regarding the welfare of the members, so and so the business. State that there was a fish market which was the largest in Guwahati city in the erstwhile so and so. The entire market was gutted completely in the devastating fire incident that took place on ground, rendering separate as to the direction of so and so. Accordingly, the allotment of the shops and slabs in the newly constructed GMC market was done in the following ground floor, so and so ground floor. 955 numbers of fish stores. At the second floor, 102 numbers of grocery. At the second floor, 484. Where is the allotment?
This allotment letters, madam, I have brought it to return that, but this is not.
You have a copy of it?
Yes. The basic difference, my lord, is there. Our rights is that we are allotted because we are having it, and we are original, that's not. Street vendors, madam. Street vendors is different from.
No, what does the members of the petitioner association do?
They are given such a place that where the fish trading cannot be possible.
And where? In Assam, fish trading is not possible.
Madam, in
Any place.
first floor, maintain floor,
Now
madam.
go somewhere else. Give them in Pamohi.
No, madam, this is our market, madam. It is there. under
What
the-
are they? You have a right over the land.
No, no.
Then my market.
We have tenants.
Goodness.
We have tenants, they 100 years.
Huh?
Since 100 years, we have tenants. Since British time, madam. This is
Tenant
what-
of whom?
We have municipality, Guwahati municipality after the GMC, after 70.
Yes, Guwahati municipality happened when?
In 45, madam, our allotment was there under this. Then, madam, GMC, then time still took place. They assured that we did the allotment.
No, when did the Guwahati municipality happen?
Before GMC, Guwahati municipality.
And that I know. Before 1971 it happened. But when? And you are saying for 100 years.
No.
And you were burnt in 1989.
No, madam.
Then
23 or,
are you doing any business out there from 1989?
no, madam. Then
Then,
45 is
and what are you doing now?
now, my lord, they have taken a decision.
No. First of all, you tell me what are you those members doing?
They are not somebody doing many work also, I don't know, but they are still, education is there, my lord.
Where's your members list?
My lord, in-
That is very relevant.
yes, ma'am.
How many people are alive
Now I can collect.
who were doing their business in the year 89?
How
23 and another how much? The year 11, 34 years. And prior to that, if you were doing some business, how many people are alive?
Now I can collect contact, my lord.
And 34 years, you have not done anything. Now you are making your claim on the Medline floor.
They take 23 years to construct the building, that is, within 1 year, they have to construct the building.
You say 23 years, in the writ petition, it is written as 17 years, whom to believe?
Madam,
Then,
I can contact only 17% or 15%, maybe epidemic and 55, I cannot contact my lord. That also is. They were adopted that particular.
and what is your right to remain? Are these for all times to come?
Really, they have to pay rent. Yes, ma'am. They are paying rent, but they are without business, they are paying.
And this was done then. And this was for how many years? And I don't understand, Mr. Bora, what is this? You are giving allotment order for how long?
But there is a condition for, there is a condition, really, they have to pay rent.
Understood, they will pay rent. Is it heritable? Tell me. Then under what circumstances these type of allotment orders are given? That day I have passed an order in a case of municipal, Assam Municipal Act. These are government municipal properties. And the person who have taken allotment have taken it for as if it is a transferable, heritable, permanent land. Why is it? Then there's not only that, they sell it. And your officials, not those people, that was a case of Kharukut. This board has been allowing it. And why these allotments are given for all times? The allotee shall deposit as a security money and so. Refunded and so. And what are you doing presently? You are not in a position.
My lord, that they feel that the maintenance floors are surviving without any business, but now they destroy it because this is a handing zone. We are in handing position because they have taken decision that we will be accommodated in ground floor.
And ground floor has been given to somebody else.
There's a space, my lord, space. Ground floor, what is that? Now, there is a decision
Of
of the very council. We know what is that.
page number 45 of
This is the decision, my lord.
writ petition.
Okay.
Yeah. Status of shifting of the SSOA. It was apprised in the meeting that for accommodating the SSOA demand for renovation of the same is under protest. The joint so informed that the Medline form the land there were some fish stores and food stores and the same will be shifted to the ground floor of the IMAR. From the meeting regarding the verdict of the High Court on so. allowing 3 months time. Upper tribal reserve for shifting of demand has been approved and the commissioner was authorized to do the needful. Now here, who is there? Mayor.
It is taken on second November 2017. Mayoral council is pending on case.
And they are fish vendors.
Yes.
All.
All.
So the fish is no longer there.
You can assess from, do not want to go there. Please tell us how can this.
Huh?
The assessor traders also reluctant to go there. How can they sell fish in dark position?
So they don't have electricity.
Let's see.
Then you put up the lights out here and you see there is no electricity, it will be dark. And are you saying that the court cannot function?
Madam, in Assam, I have not seen a fish market in second floor. All are ground metal. What I think.
So with you being there, so is there a second floor there? There is a second floor. Who is there?
The other shops are there.
What shops?
There are multiple shops, different shops are there, other shops are there. But they all are. In fact, Godown, this is Godown, subject to my correction, all are Godown because they cannot upstairs to second.
You had an air conditioned place in 1989. Because of that, the fire took place.
We are sitting in an open space, madam.
Open space, and now you have a right. They are not a single fish being there, all this.
And they have not.
Filing of these petitions unnecessarily.
One thing I can place the judgment, I have been commenting this honorable general said that we have looked them.
Huh?
There is a direction of this honorable president, we have looked at acts matter.
Where? We are not concerned. The question doesn't arise. The question doesn't arise. The problem is not there. The state can very well say that yes, we can rehabilitate you. But where is the question?
Space where we
You
have.
want to go to Amingam?
No.
Amingam is coming up.
I will take it. Direction is that in this place of fire, there,
You wanted it only in Fancy Bazaar.
we are original, but all of street vendors.
No, first and foremost, what right do you have to continue for all times? Tell me, show me that right. The GMC does all these things. That's a different thing. But what is the right? Can you say that the municipal property can be given for all times to come?
There, but you can,
Are you saying the Street Vendors Act or all the acts takes away the municipal rights over its own properties?
we are not street vendors. They are, have
You had no shade. You were doing it in the open market.
no, madam, that by that time, prior to 89, there is a fish market in the ground, madam. And there is some states that all are destroyed, then multiple buildings constructed. So we demand that we should be accommodated in ground floor, but they have not done. Now they take a decision that,
And here we are only having 25 persons.
yes, well, now we can contact only that person. So they have shown a affidavit also, but they are still with that business, madam. I will bring it in the records, madam.
Your best is one thing. How many affidavits are there?
Others is 14 or 15. Because somebody dies and I make queries, then they. And
They are no longer there.
no, they are doing,
Does the legal hair also have a right?
not right. Who are,
Let us see the GMC Act. This is done under what provision? The GMC Act concept. Mr. Bora, you get me on next Thursday. What is the area?
my kind of,
You admit that there are 230 members of the association. How can they be accommodated? Can all these people be accommodated? Because you have said that all these SS house, SS Hoppers Association will be accommodated in mezzanine floor. Let's see the municipal properties. How can a municipal property remain for all times to come? This is very difficult to understand.
that is our claim, our claim is that, but we take a decision in your claim.
You cannot have for all times to come.
But we have it from- with some reason.
Municipal property, wait, here. We have got it, page section 101. And these things needs to be set it right. The corporation shall, for the purpose of the have the power to acquire and held immovable property of acquisition of human property where we go. Governing the within the state of the So see 104A. The commissioner may, in the interest of the corporation, dispose of by sale, which is not so because you are asking them money. Letting out, which is the case, or hire or otherwise any movable property belonging to the corporation not exceeding 10,000 in value in each instance, or grant. Movable property could be sold, hired, or grant a lease of any immovable property belonging to the corporation, including any right of fishing, gathering and taking fruit and the like for any period not exceeding 12 months at a time. Then, if this is the mandate of the act, how are you doing it for all times to come?
Allotment is given by law. At 12 months, they put it in. If they even- if person have not put it in,
Forget about the annual fee, but how are you doing it for all times to come? Then you see. The commissioner shall bring such transaction to the notice of the standing committee within 15 days with the sanction of the same may dispose of the sale of movable property, which is the value of not exceeding demand, and may an immovable property belonging to the corporation, including any such right as aforesaid for a period exceeding 1 year, or sell, grant or lease in perpetuity. Now see, perpetuity of any immovable property belonging to the corporation, the value of the premium which does not exceed 20,000 rupees. This has to be done with the standing committee. With the sanction of the corporation, the commissioner may lease, sell, let or hire, otherwise convey any property, movable or immovable, belonging to the corporation. The consideration for which any immovable property or any right belonging to the corporation may be sold shall not be less than the current market value. The sanction of so and so may be given as the provisions of that section and the rules made under shall apply to the disposal of PIA, provided no property vesting in demand shall be leased, sold or otherwise conveyed in such a manner that the purpose for which it is held will be prejudicially affected, so and so. Then so these fishing rights has to be within 12 months. Then what are you doing all these things? And these documents, letters of allotments, who have done it? By the commissioner. The allotee shall deposit a security of rupees 8,000 only and the registration of so and so, and will be refunded to the if he or she vacates the room or so and so and so so and so so and so. Shall have to pay a monthly rent of 10 rupees per square feet in the ground floor, 7 rupees for the mezzanine and 5 rupees for the first floor, fixed by the corporation, and same payable in advance in the first week of each month. So every month. And for how long you are giving this? Not necessary. Then why? You can't do it. The commissioner has no power to do that beyond 12 months. Then what is the effect of these allotments?
They allotted and they put me the rent. That was where.
You see, no, you see further, I don't know with these, but you see the page 108, the last document of that. No, Mr. You also don't have it. You have not served a copy. How did you file it?
Because not file matter, because page number to this page matter, new additional page number is
Understood, but without serving, how can you file it?
now. Plan has gone to this.
Very well, very well, very well. Here it says the terms and conditions of the allotment of stock will be informed to you at the time of handing over the possession of the stock. So if these allotments cannot be in perpetuity, which is being done, and that too for fishing. Don't ready. List this matter on Thursday next. 21st of September 2023, on which date Mr. S. Bora appearing on behalf of the GMC shall apprise this court as to what is the size of the mezzanine floor and as to whether the members of the petitioners association, that is SS, it is a Hawkers Association, so can be accommodated in the mezzanine floor. Mr. Bora shall also take appropriate instructions as to what is the height of the mezzanine floor and let's take order. Mr. M. J. Borua, appearing on behalf of the petitioners in WPC number
183.
so and so, submits that he has filed an additional affidavit before this court. Because the registry shall bring on record the said affidavit on the next. Mr. Bora, just find out what type of allotments you have given to those vegetable owners. No, it can't be in this manner. Because here, the moment I say anything, this will hit others also. It has to be annual. I can't have it for all time.
Five for hearing.
Oh, that one. How have you linked the name of the petitioner, the name of the respondent number 7 with the land? Who is appearing for the government? Miss S. Sharma was appearing on the last occasion. Where is she? Are you saying that you have no instructions?
Yes, the file is being retained. So I'm not.
Then why is she not present when the matter is called? So should we also make it clear that the name should be also indicated in the cause list? Then only they will appear. Laho. Mr. S. Borua appearing on behalf of the government submits that he has no instructions as the file is retained by Miss S. Sharma, the junior government advocate. This court, by an order dated 7/9/2023, specifically instructed the Miss S. Sharma, the junior government advocate, to apprise this court as to how the authorities concerned have linked the land revenue records pertaining to KP Patra number 25 in the name of Haro Koibotron with the petitioner's father as well as the petitioner. However, no instructions have been placed before this court. List the matter again on 28th of September 2023. The Mr. S. Borua, the learned counsel appears, government advocate shall apprise the senior government advocate Mr. D. Nath about the displeasure expressed by this court about in view of the instructions not being placed. The Mr. D. Nath, the senior government advocate, shall do the needful so that the instructions are received on the next date. Failing which, this court shall cause the personal appearance of the officials concerned on such date as may be deemed fit by this court. Next.
Item number 6.
Yes, Mr. What is this matter?
Small matter, like small question of the record. Now, if you find the petitioner father, he was working in the Anand district in the year 1960.
Just 1 minute. Some notice you are challenging.
Yes, the notice will find.
Letter of allotment made in whose favor?
This was in favor of Shah. Now the question will arise whether the DC can issue any order under that. Now since if the land is issued in favor of the Shah, Shah must do committee member. Now in that case, it is they who should file an appropriate suit before the vote to anything. Now how come they have the power? You know, to see the order.
Now let us see that order, page 27.
Please find it page 27. Order dated 20/10/2013.
This is a notice.
A notice.
You are hereby informed that in pursuance to the decision of the meeting between you, undersigned, and the office bearers of Assam Tea Labourers Association. What is this Assam Tea Labourers Association?
This is
Assam Sal Muslim Family. SAMA. It's actually Association of Legal and
That I know. But you have made means the English in such a manner, the translation has been done in such a manner that even the edifice of the case of the members association is also changed. I hope tomorrow my name Devashish in Assamese you don't change it, yes. Assam Tea Samuzdur. ACMS. Which was held in the office of the undersigned, you are requested to vacate the illegally occupied residential premises of the Tea Labour Association within 7 days. Therefore, as per law, you have been informed through this notice to vacate the residential land since the aforesaid land has been allotted in the name of the occupancy. Aforesaid land has been allotted in the name of so by virtue of the election. So you are challenging this.
now you must see.
It's okay. Yes. What is all these things? The deputy commissioner doing it. They have a fight between the members. She was a member or not?
at one point of time.
Okay. There's a fight between the member, erstwhile member or member with the ACMS. Why you are entering?
Then for allocate my not to SAMS. Wherein my not they have that was somebody.
So who are you?
That is the precise.
Who are you? What are you doing? You are exercising 18. What? What power you are exercising? To asking them to vacate on the basis of a negotiation entered into. You are enforcing a negotiation. Is that the status of a DC nowadays? Or then? Then. Now you have changed. You have allotted to ACMS. Now it is their private property. Now that property, they have somebody is encroaching. Who are you? If you were to allot, you were thinking of allotting, and it was a government land, then you could have. It's a private property now after allotment.
That's why I was on my.
Yeah, now,
Since allotment here, that allotment order is at 12 June 2013.
uh,
It was from the Deputy Secretary Government of Assam to Deputy Commissioner of Lakhimpur.
mm,
The land was allotted to us.
mm,
We had 3.12.5 lesser.
mm.
By that, allotment is a merely a formal order. How is it? The allotment is a efficient order.
Mm.
There has to be a settlement.
Mm.
Settlement has to be done again for the settle official, zonal official.
Mm.
So land, unless otherwise the land is specified, government land to private settlement, what do you call, patta land.
Mm.
Till that time, it is not allowed to me. It is, even though it is allowed to me, it is not settlement for us. Settlement process is yet to be done.
So if that is a settlement to be done,
Lordship.
how does the deputy commissioner say that you have entered into agreement with him? Why is it that it may be a case between him and the deputy commissioner? How do you bring into it? If you say that no right clause on the basis of the letter of allotment,
We have been best party in the WPC.
understood? Wherever you have been made, obviously you have to be made a party because your name is there in the notice. But you say that you don't have a right over the land till now.
I have only my right to talk.
As of now, do you have any right?
No, it is
You
a
don't have.
government.
So you take your seat. He has no right. Then why, at his instance, if he doesn't have a right, why you are taking any action against him?
Allotment is one of the preceding exercise for settlement. Regulation does not define allotment anywhere. It's just about settlement. Now, allotment is always considered as for this purpose. So, the land was allotted for specific purpose that the office of the town will be constructed there. Now, getting into upon that condition, because there, this was one of the implied in the allotment letter.
Hmm.
That was violated by the victory seller. So therefore, the deputy commissioner has all the jurisdiction from that agreement.
What, see your notice. You are requested to vacate the illegally occupied residential premises of the Tea Laborers Association. Then, how is it? Your basis, the edifice of your notice is wrong.
No, Lordship.
If you are saying on that.
So if my lord comes to the particular, maybe my lord, my lord,
Let us read it. ERB.
only, only the ইয়াৰ দ্বাৰা আপোনাৰ ব্ৰহ্মৰ জাগে গোটৰ ইংৰাজী ইমান পাৰিছে অসম চামুদ্ৰ সংগঠন আৰু আপোনালোকৰ লগত নিম্ন স্বাক্ষৰকাৰী কাৰ্যালয়ত হোৱা আলোচনাৰ সিদ্ধান্ত মৰ্মে আপোনালোকে অবৈধভাৱে দখল কৰি ৰখা চামুদ্ৰ সংঘ বাকীহতি 7 দিনৰ ভিতৰত খালী কৰি দিয়া।
That is what? The residential place of that Samudra Sangha. Then,
It is founded residential place, but it is allotted to Samudra Sangha to carry out the activity.
So,
Now,
on one hand, if you are saying that the allotment has not happened to that respondent, it's a different aspect.
actually, but minority countries see the same of events here. The meeting was held between the petitioners, the Samudra Sangha persons, and the district administrator. And there a decision was taken. And a consensus was found. Now they cannot resign from it. Why for that? Because they are under 226. It is correct. I will have to satisfy myself that I am exercising the jurisdiction within the.
You giving, understood. If there was an agreement between three of you, you not exercising your powers, being the additional deputy commissioner, it is understandable. You are saying that you will exercise on the breach of an agreement. Fantastic, you can do it as per the civil remedies on the breach of an agreement. But how can you exercise now 18 or 18? Then what is your power? Under what authority you are issuing this notice? Do you have any other authority? Tell me. Only power is 18.2 or 18.3. Then what is the power? How can you exercise that power? Unless it belongs to your land.
Lordship, she has, on receipt of the notice, she replied to the PC that give me 1 month time so that I am not well. Thereafter I will package. Instead of packaging, she has come. So therefore, she has waived the right. I have filed that. Wait.
The second is there.
I have given. So she has agreed to vacate the property within a period of 1 month.
Show me that.
Uh,
But then also this becomes very difficult for this. It is something, Mr. Babuja, it is something like last time, yesterday's matter.
It is in the IA 1554.
No, first of all, you have no business out there. Where is that? Upoyukta CMS. And this is preceded by some 2012. Let us read this document, Annexure 10, page 63, running page. To the Deputy Commissioner, Assam Shram Mazdoor. Would like to inform you that we made an application for allotment of so and so, but it is quite unfortunate that only 3 kathas is shown in the possession. An allotment was made for the year. It appears that the interest of so and so repair has been ignored. Sir, you are aware that so and so month instead of the whole plot of land, only 3 kathas have been moved and the same is not acceptable. Where is that document? You have not enclosed it with your affidavit. Where?
In my
Mr. Dotto, you are in possession of whose land?
It was initially with the government. And I have been studying since 19.
Huh?
Since 1963.
Have you applied for allotment?
Now, it was done. Initially, it was granted. Thereafter, the Lord, they applied and we lost it. And you see, my affidavit in reply, they are saying that if the shepherding land has not been allotted to them, but then the annexes from something else, they cannot deny all that. Because I'm just reading out.
No, page.
Page 13, that page 13 of my affidavit in reply.
When did you file that?
Was filed on.
Mr. Dotto, you have your juniors. Why you are not asking them to make this pagination properly? This is not the manner in which one does it. Now that other page number is removed. So we don't have it. I am handicapped. Now I have to keep on searching. There is an affidavit filed on 26th of August 2014. Is that the affidavit? What affidavit you are referring to?
We have filed the reply.
Understood. Affidavit in reply against whom?
The respondent number 2.
Respond number 2. When did you file? Got it.
Now, you also can see the annexure, page 13,
Huh?
page 13. Annexure,
Yes.
12/6/2013. From LC Secretary to the Deputy Commissioner. With reference to your letter of the subject cited above, I am directed to say that the government person is pleased to order for allotment of secondary land measuring 3 cutters 12.5 covered by 2024. Into the favor of Assam Jamati. Now, this makes the thing entirely clear. The entire land was allotted to them. And now they are saying they do not have any right. Then they can relinquish their right. In that case, my lord, our acting that we can get it back.
Okay. Now, what is your right?
So I don't have any right unless the allotment is.
So you don't have any right over the land. Have you filed an application for allotment?
We have filed an application, it was initially granted, when we have stated in our petition.
No. Where is it? You must have submitted some application, some number will be there.
The revenue also I have paid, that will also be fine. At page 22 now. 22 and 23.
What is your name? Anjali Devi. Certified that government land 0 Katha 018 letter covered by Dag number 275 under so and so. Under revenue circle has been occupied by Sothia Devi. Who is Sothia Devi? You are Anjali Devi.
I'm on very good.
Then how does Sothia Devi come into the scene? Wife of Sri Ram. On one hand, here you are saying Anjali Devi, wife of Sri Ram Singh. How many wives does Sri Ram Singh has?
None of you said that.
What allies? No allies business. Where is it? No allies business. Is issued to the applicant by so and so submitted after the certificate is issued for obtaining KCC loan. No, there is no delegation. Has been received from the so and so of Imam.
Next page, you will also find.
Let's see.
Initially, there were 3 kathas of land was allotted.
So you are in occupation of how much? 15 letters. So the allotment has not happened. But allotment has been done, but not being effective.
I have the case again.
You have been in possession of the remaining land?
See what I am.
You are in possession. How?
I have to actually practice that because since long we have been possessing, and he was one of the office bearer. And as an office bearer, he was allotted, he was also.
So you were in possession earlier.
Definitely, it is a government land whereupon we have been possessing, and he was one of the office bearer.
So you don't want to accept that allotment. Had the allotment resulted into a settlement?
No, because
Has-
repetition has been filed.
So where the repetition has it been stated that the settlement
Yes,
should not be
sir.
given?
Not repetition order.
There shall be a stay to the impugned notice
Yes.
only.
Yes,
Then
sir.
what else?
That has been
Mr.
said.
Borbujari,
That has
what
been-
has happened to the allotment?
Allotment could not.
That has only been allotted. Have you changed the names? Have it now been made a patta?
No.
Then why?
That letter of allotment, formal letter of allotment from that government, get minority signed in the affidavit of position filed by R4. And respondent number 4. R4.
Yes.
R4. And minority signed in the-
Huh? There is no affidavit in there. There is R4 affidavit in reply.
So when it is definitely the position for the that is filed on 12th of February 2014. The deponent is one from the Catholic.
Got it.
Yes, they are minority.
Handing over report.
So, handing over it, but they are so under municipal kindly come to case A. That is Annexa B of.
So this handing over, you have received it, Mr. Annexa page 36.
As an allotted, we have received.
No, you have received it, handing over possession.
And the handing over procedure respects of 3 kotha only.
No, 3 kata 12 and a half letters. Well, 3 kata 12 and a half letters, you have received it.
or they have been illegally possessing.
So you have received it on their behalf also.
That part is, no,
Yes.
that cannot be.
So then you have no right in respect of the others because on 2/7/2013, you have received the entire amount at the total allotted area.
Entire amount was given, thereafter we have posted.
Are you saying that they are in occupation thereafter?
There, yes, there in the.
So they entered into occupation after 2nd of July 2013, not prior to that.
Not, they were there in office bearer. Subsequently, they claimed it as they have been opposite. That is why they said that they have reflected that, oh, DC that we are going to have it. We have been possessing it, we will never give up that sometime. That level is there. In my, what is it called?
So they are residing out there in the land or the building.
In the level, no, there is a small house, belongs to SCMH, wherever they are staying there, it is.
So it is therefore, it is a case of interest between landlord tenant or whatever may be. They are in now registries of, they have least left it.
Lordship, so long the land is not in, or the character of the land is not changed, it is not a settlement land.
So are you saying that they,
Government land.
no, forget about the government, that are you saying that the house does not belong to the ACMS?
No, it belongs to us. We
So
don't
here
own
they are in occupation of
No,
that
they are-
house,
they are partnership occupied. He is a-
of your house,
Because he is a office.
of your house.
Of my house.
So if they are in occupation, what is the DC doing all these things?
DC was given because the subsidy we applied for, we have applied long back since long. back.
Okay, if they want, we can close down the civil courts, ask the DC to do everything. They were earlier doing it at one point of time in all other places prior to 1945. Let them do it. You want to adjudicate nowadays?
Lordship,
Then
Lordship, before the and decision letter, which the petitioner wrote to the DC. It is a.
you say that it is their house.
No,
Are you saying that the house is yours?
it is fine.
They are in occupation.
They are illegal occupied.
So-
The initially the permission occupied, subsequently illegal.
If that is so, it is a dispute between both of you. What is the DC has to do?
No, but so after all the land belongs to government.
So what? They are not on the land, they are on the house. Or if otherwise, this report shows that you have got the entire land, then that land is different. You have taken the possession as on 2/7/2020, 2013 of this 3 kathas 12.5 lectures, which was allotted to him.
That is the formal announcement. That is the formal announcement letter. Everything will be rolled around this government.
No, that is the formal allotment letter, and after that possession has been handed over on 2/7/2013.
Now, my lord,
So, and he has received it.
how the DC order, the district commissioner for that matter, exercises will be.
No, no, tell me, after handing over the possession to him, which he has received it, does the ADC still control over the possession of the land? Matter ends, the ADC can't do it, it is a civil dispute.
Either from the parties, if one of the parties, he says that please give me some time, I will get it. Now, that particular letter, whether that letter was issued by the administration of official, those things were not on record. Either was controversial.
That document is not before this court.
Yes, Lordship, I have filed. 1554, affidavit I have filed.
Show me that.
That is the only genesis of my lord.
No, then also this court is going to set aside that document. That order has to be set aside. Thereafter, leaving it between them and him to know as to when to vacate. I'm coming in 5 minutes.
So that matter, the record has been traced out and communication has been sent. On the next day, I will just make it.
Order remains like this.
So there was a.
Your junior government advocate very well knew about this matter. And you should know, nowadays we don't have a part 2 list. All the part 2 lists matters are being brought in part 1. This is how it is.
So their confusion has.
There couldn't have been any confusion when the matter is there. And are you saying that the list does not appear? The names are not there of the parties?
Parties are-
Then Matter is, don't make this type of submissions.
At least that part gave me written that, so it was on my mistake. At least that must.
That is what I want to put it. You want something more to be added, I can do it, nothing less. That is absolutely irresponsibility on the part of the council not to be appearing when we put the names of it in the order. Sorry.
Because advocates keep on rolling. We have different concepts, like the last time, so it was appearing, and this time it has been allocated to me. So that is my humble submission. because-
It has been allotted to you, you are not responsible, you say that you don't have the file. I can't help you.
Yes, that must be a person as per as-
No, nothing doing, these things are not. You have to be serious when the matter is has been allotted to whom. It is the senior government advocate who has to take the call out there. Her name was duly appearing in that order, asking her to take the instructions. Yes, sometimes somebody else obtains the direction is given to some council and the other council places it. It's okay. But if that the council says at that point of time when the matter is taken up, that the file is not available with you and the file is there still lying with somebody else, then this court can't help it.
No, that was the communication I was sent. So this is my mistake. In fact, I just humbly apologize. At least that was correction may be given. On the next day, I assure that this record will be there, but at least that person, the name may be given. My humble apology. Because rightfully she has communicated. If there was a communication that between the office and me, all this I have to insert the commission. Finally, it has been traced out that those logs are retaining the file that I am having it back. That must be. Humble request.
So you have no instructions on that.
Yes.
We call that person, you have communicated, then also the person has not come. in.
That part may remain.
Now that person, and then I'll ask the personal appearance of that person concerned. If I look up. That, because you say that you have communicated and he has not responded.
Communication has been done, but whether the record has come in order.
No, I'm not on that. You have to take that responsibility.
Can you?
No, Mr. Bolwa, you have to take that responsibility. You can't make an statement before this court in thin air. You have to take that responsibility. Yes, the communication was sent and the officials have not reported back to you. You have to have the.
Can you also pick it up at 2?
Inform the other side. But if you don't have, then we will presume that in spite of your information, the person concerned has not informed. And as such, I am going to call that person concerned. Make it clear. Yes. Which document you are referring to?
That record is not there. They have filed the TDB. They have
Who
filed
filed?
the application for paying for renovation of the building room. Presently position of what.
Where is the document?
That
You
I
are
have-
saying somebody has made either both of you, one of you have made a statement. No, don't show me all these documents. Is it a part of the record?
Yes, it is a part of the record.
Which document?
1554 IA.
Yes. Can I? Okay, show me that. You have it with you.
No, sir.
This letter is written to whom?
Deputy Commissioner. Deputy Collector, the paying for time 1 month time.
So
So
if the deputy commissioner has no authority writing to him, would it amount to anything?
Notice was issued by the Deputy Commissioner there.
So what? If the notice goes, anything written subsequent thereto, does it have any value?
Lordship, admittedly in the government land.
It is not a government land. It has been allotted, handed over
No.
to you.
So long it is not
So you admit that the land has not been handed over, no allotment has happened to you.
Handing over was given, accept that part.
Then why did you take over the possession? Why did you document at page 6? Annex A. You say that you have taken over the possession. It becomes an inter-se dispute between you and him.
10 years past, under it is given to institution, one of the institution. He is one of the member of the institution. Subsequently, he misused that.
So it's a case of a gratuitous person possession. You have to file a suit.
In that case, right? Even the notice goes, if the notice goes, that means it is a case dispute between the parties, private dispute.
Absolutely, both of you.
In that, what is it called?
So let us assume
Discuss the relevant-
they are in 13 lectures of land or 14 lectures of land, whatever it may be. They are in 13 or the house.
It is a house.
Tomorrow, in the remaining 3 kathas of land, you have some house.
We have to do.
If you give it to somebody on rent or not on rent, for allowing some office bearer, your president, you allow him to remain there, and the president does not leave, are you again going to take the help of the deputy commissioner?
My time, I got to my land has to be settled.
No, understood. So therefore, as of now, you have no right over the land. Are you saying that?
Except my position given by the permissive position given by the government.
So you are under the permissive possession of the government. So you don't have a right over the land.
I have no right except position given by government. Because that is why notice issues should, even if it was 18 notices required, even then 18 to subsection 2, notice is not required. Say, under section 18, notice was given to them. They agreed to vacate the property, but subsequently they defied and they came to position of it.
So we will assume that you have no right over the land. Can we do that?
No, it is.
Now, I'll pass an order to that effect. You have no right. That is your statement. Then obviously, then the deputy commissioner can take it. Taking it that he is in possession of government land, not your land,
Then the deputy commissioner can exercise power under section 8.
but not on the basis of that.
Lordship, that I will agree that. the deputy-
But I am going to record that you are not. This handing over has become non-est in view of your
in view of the
statement.
law.
In view of statement, the non-est handing over allotment letter will become non-est.
But deputy should also, should have a
You
right.
don't accept the handing over as well as that allotment, and no rights have flown upon you. Are you going to accept that?
I'll have to take it such.
No, you are to make it today. This is a 2013 matter.
But see, I have also that a problem because in that case, it is a federal institution land. Three kotha has been, we are in a position of three kotha. Remaining pure lesser is under their position. So there is a small assembly house, wherever they have been living. And they have a permissive occupier under our.
Your basic case is that house is yours and they are in occupation of that
Yes, which
illegally.
because he was given opposition.
Whatever may be, you are saying it to be illegally. Your case is that.
No, till that time he did not, till that time he remained in the office bearer, he was not illegally doing it. Thereafter,
From when did the illegality happen?
just after his death, because he is no.
When?
I have quoted in my affidavit.
When?
This man died. Ram Singh died.
They issued a notice on 2011-2010.
Who?
Some 17 no.
Huh?
Ram Singh died on 17/5/2012.
And why the notice was issued and you took over the possession in 2013?
Lodge.
And thereafter, The notice was issued in 2013. So after the death of Ram Singh, the petitioner did not have a right to remain in possession. So the illegality happened prior to that. As for you,
Yes.
the further possessing the land, the house beyond that is you. And it happened. Then it is a dispute between you and him. How do you involve the deputy commissioner?
In one way, Lordship.
That is
So
the
long
only
my
way.
land is allotted to me only on allotment. I have only a possession of what I.
Are you also being allotted the house?
So long it is not settled in matter. Settlement is next process. After all, it has to come to back to back and settlement officer. It has to serve, land has to be classified. whether
Are
it
you
is
saying
town
that the settlement, it has to come to the settlement officer?
Lordship.
Why?
Allotment is a administrative order passed by the government. And so and so can be allotted, so and so institution.
Who gives the settlement?
Settlement is after once the government agreed to get settlement, after allotment, thereafter settlement has to be started. It takes 3 years time. Then in the settlement order itself is given the allotment order that you complete the settlement process within a period of 3 years.
Mr. Bhagavati, the allotment order says that if you don't utilize the land for 3 years, then it will revert back to the state.
Lordship.
That means what?
These 3 years.
The land has already been allotted to you. It would not be revert back if you utilize it.
Yes.
Then why are you making these type of submissions? You make these submissions before any other court, it is okay. Right, left and center, I'm only doing this revenue matters, and you are telling me. You are saying that the settlement officer will do it. Settlement officer only does a settlement at the time when the settlement proceedings are on. Otherwise, it is the duty or the power is only reserved to the deputy commissioner. The deputy commissioner has to do with the approval of the government, that's all. Whom do you file an application for settlement? Tell me. Whom do you file an application?
Deputy.
Okay. So it is the deputy commissioner who has to do it.
The home settlement, Lordship, it is deputy.
How do you bring in the settlement officer? Are you saying that the settlement of proceedings are going?
Because settlement proceeding, it was not going there, but only thing, it has to be classified, it has to be assessed, then the class of land has to be, all these things has to be also done.
What? The land, are you saying that land has to be classified? It is already classified. See
No,
this
but-
document.
If
What
not,
are you saying that the land has not been classified? The land has already been classified as second class Basti land. What are you saying? This is being done under the Assam Revenue Assessment and Reassessment Rules, 1945.
I have a problem now, problem is that, suppose I go my allotment, then that case I am losing the cheap. Suppose I go for the other side, again this.
Mr. Bhagavati, why don't you concentrate on a case? Forget about his land. Concentrate on the case that he is a gratuitous possessor of the land, of the house, and fight him out before the civil court.
But in that case, that will be only related to from.
That is the judgment of 2002. 6 SCC, the Supreme Court makes it very clear. He has no right over that. Go on that.
In that case,
There is no other way because you have already, because the moment you are accepting the possession you are taking, you become the owner of the land. It will only revert back if you are not utilizing it. How can you revert if it is not been given to you? Tell me.
Making my submission in that case, will change in the year 2013, understood? The UTC was filed. From this one, for industrial that we just notice. At that time, if the notice was not relevant, at that time, notice itself should have been set aside. Thereby asking us to go back to civil court. Now, 13 years passed. Now, because of pendency of this, I cannot go back to civil court also.
Why? Why are you saying that you can't?
After all, there was something on the basis of, because title of the land was being questioned before December 4.
So,
So my right to go back to civil court was limited at that time. That is 2013.
isn't the possession which is there whichever possession which he is claiming, isn't it a continuous cause of action?
In that case, cause of action alone, without my agent, because those still that time only allotment was there. I just-
Mr.
I did not have a document to show
Mr.
that-
Bhagavati, why you are spoiling your case by making for these 12 lessons? You have been allotted the land, the right, the land based upon you. You see, the allotment is nothing. What is an allotment? Tell me. The allotment is a proposal for settlement which has been given by the deputy commissioner, placed before the government, and the government gives it. Yes, give it to him. And on the basis of that, the possession has been given. Now, by virtue of section rule 16, you have a right pending the lease being issued to you. That is it.
All right. So we have spent one time to development.
Yes, please. I have all the time today.
But allotment, simple time, the land has been allotted. Till now, the allotment has not attained the status of the Pakata. And has not been settled. So he has not attained the status of the Pakata. So he doesn't come within the definition of a proprietor or settlement holder or landholder, which is the meaning of regulation. So, and minus super, and then you can also that revenue efforts pertaining to this particular sort of land is done for minor as of now. So we find that so land which is allocated. And the name of the allotee is mentioned here. That's like one of the name of the partner. And in the remark column, it is stated that the reserve land will be government land. But it has been empty, but it still continues to be government land. Now, you still take condition for exercising the power and the ability. Rule 60 minus always and we want it speaks only about wasteland, nothing else. The rule 16 says prohibition to enter into land until use of lease of lease. Lease shall be issued on legal application only, and no person shall enter into possession of wasteland in any area until a lease has been issued to him or otherwise a written permission by deputy commissioner has been granted to him pending issue of such lease to enter into possession. Lease here really means by the patta. Now, there has to be a written communication. There is a case, neither of the party has been issued with any lease, but one party has been given allotment.
Not only that, the circular officer, upon being delegated, handed over in possession, meaning thereby the purpose, the lease has been, a permission has been given by the deputy commissioner.
But it has not culminated into issuance of a lease. Right. So therefore, since it has not culminated into issuance of a lease for this period, for the interim period, wherein one of the parties are in possession, the land in question would still remain, in my expectation, with the minus correction, as a government, it will be in the nature of the government, because lease has not been affected. Once lease is affected, minor it changes the character. Then, of course, minor architect comes into play. Now, minor I am taking rule 18. For a moment, minor. Rule 18 says, rule 18, sub-rule 1. Subject says, here is also provided that the deputy commissioner may eject any person from land over which no person has acquired the rights of a proprietor, landholder, or settlement holder. Now, proprietor might not necessarily might not.
Mr. Borbujali, kindly come to page 7 of the affidavit filed by the respondent number 4. The document of 1st of July 2013.
first agreement. That is a pre-stabilization. The reservation of land in favor of Assam on the number, not percent one. This point includes here with a copy of the above referred government letter, which gives for itself and equals to kindly hand over the possession of the land measuring 3% privilege covered by the Assam Forest to the requiring authority, that is the precedent Forest.
And correct the land records accordingly at the earliest. So are you saying that you require further settlement? Why? Settlement for what? What type of settlement are you proposing? How do you correct the land records? When there is a direction by the additional deputy commissioner, because here, if you see the Assam Land and Revenue Regulation, the DC means the ADC. So under such circumstances, when it has been mentioned that you correct the land records, means that the settlement has already been effected. Some land and revenue. There's no conduct. This is what it has been. Now, is it mentioned that when a settlement has to be given, it has to be only by way by issuance of a patta? Where is it? Show me that. Where is it? Show me that. That without issuance of a patta, no right is given.
Without expense of a patta, whether a person does not attend the status of a proprietor, landholder, or settlement holder. That is my argument.
Where is it?
Rights which would be provided. No right of any could have been or shall be acquired by any person over any means except the following rights of proprietor settlement also right legally derived from any right necessary so right under limitation right acquired by person as tenant. Then we know rights of the proprietor.
No, before going there, kindly come to the proviso.
Yes, provided that nothing in this section shall be held to derogate from the terms of any lease granted by or on behalf of the government. So,
The state government has given that power. The state government has allotted the land.
look at the land, but it is not been there coming down below, my lord. Kindly see, my lord. Status of landholder, how it was, my lord, accumulation area. And doubling my lord is always prohibited. Any person who has, before the commencement of this regulation, held immediately under the government for 10 years, continuously any land not included either in a permanently settled estate or in a revenue-free estate, or and who has during that period paid to the government the revenue due thereto, or held the same under express exemption to revenue, and except as provided by section 15, any person who has either before or after the commencement of this regulation put any such land under a lease granted by or on behalf of the government, the town of which is not less than 10 years shall be deemed to have acquired the status of a landholder in respect of the said land. Now, we kindly come to my lord regulation 9. This will be important here. A landholder shall have a permanent, heritable, and transferable right. Now, here, my lord, the LOPs do not have the transferable right. Transferable right of use and occupancy of this land subject to payment of all revenue taxes, from time to time. And the reservation in favor of the government of all trades and all mines, minerals, and of all buried preserves. Paying the same, paying to the landholder only compensation.
Are you saying, Mr. Bhagwati, you are not paying any revenue now?
No.
You're not paying any revenue. So we will therefore have to hold that you have not utilized the land for 3 years.
Because 3 years from because in the year 2013 allotted to us.
So you have not used it. Put to utilization. So therefore, that's an allotment order has to be go.
So allotment order doesn't matter specifically, might not say that you have to pay land anymore.
No. Not only that, they have not used it.
No, there is
Subject to utilization for the specific purpose within failing which the land so allotted will automatically stand cancelled and reverted back to the government. Now, how can it revert back to the government? Tell me. I don't understand that aspect. Can it revert back to the government if it has not been given to somebody?
because that
Is it now, are you saying for the last 13, 14 years, the land is in a state where neither it belongs to the government nor to him?
So, madam, this government, it belongs to the.
No, how can it revert back to the government? If this letter is, this is the letter we should, how can it revert back to the government?
The particular word, the word there, is mean, my lord, that one of the owner, one of I will use one of the limited ownership, which has been, my lord, transferred, my lord, to the allotted.
What is this limited ownership? The moment there is a limited ownership, he has a right, it becomes his and his dispute. If there is a limited ownership, then it becomes again the dispute between both of them.
So that is true. That is
So then the right, the state wouldn't have the right to exercise under 18.
can be viewed from their center. That's not my.
No. Tell me, if the land you are saying that it would revert back, it is only the correction of the records which is the question.
Yes, in correction of record.
Now, the records having not been corrected by you for all this while, can you say that the land has not been vested upon him? Say that, we record it that the land has not been vested upon him. No right has accrued upon him, and as such, the notice becomes bad because you have done it on the basis, but that also becomes bad. Because you have presupposed in your notice that the land vested upon. You say the land has not vested upon you. So on the basis of malice in fact, I'll go into this. No, that is the only angle this court sees.
The difficulty, whole difficulty lies because my lord, regulation speaks only of difference of lease. So long, my lord, the lease is not issued by particular person, but my lord, who issues the lease? So long, the lease is not issued to a person, and lease is affected on papers. They feel them, my lord, it is government, and of course, for a limited purpose, my lord, it has been allotted. The difficulty lies there, my lord. Therefore, I am.
Are you saying that every person who has been allotted is issued a pakka?
No, yes, it could have put up, yes, but subject to utilization of 3 years. Pata will be in this case, it will be issued by not.
So therefore, this notice, no right has been affected upon him.
Right, my lord, right of possession.
No, right of possession is, we are not concerned. The right of possession will be there under 16. He has been given a right of possession. That is another thing. But otherwise, there is no right.
Yes, he has a right, my lord, only to possess and utilize. The end.
No, how can you utilize?
That is the utilization of that.
The moment you go into the question of utilization, it will the question of reversion will also come in.
That's what my lord it says.
How can it be reverted if it had not been allotted and given to him? Tell me, are you saying that now it is in cloud 9 that the particular, what do you call, the rights of that land in question is not there either with him or you with the government? Then who is now the owner of the land?
Regulation speaks only of lease, nothing more, nothing less. Now, here is a case, mother, where you can speak about it. It has not been leased out. Once it is leased out, then it will convert into expense of a patta.
are you saying that without issuance of a lease by the deputy commissioner, no rights, and as no lease has been issued to the respondent, no rights has affected upon the respondent in that sense?
Except possession and utilization. Possession is.
Utilization is different. Utilization does not come into the scene. How can there be a utilization? The utilization does not come into the scene. At best, it will be a possession on the basis of the edition or letter. That's all.
My understanding, possession understanding. I am allocated with the 100% of the land. So, but I will have to use it, definitely for some purpose, it will be allocated to me.
No. You are, there again, you are making a mistake. But if that regulation does not have the concept of allotment, then in that case, it is only on the basis of a settlement, that too by way of a lease. That too by way of a lease. So therefore, no rights can accrue on him.
Exactly, my lord is correct. But here is the business. In allotment, since the land has been handed over, you use the land. The
Using of a land, that is a permission being given to him, which he has duly accepted the entire possession. Only for use, not utilization. Utilization would not come into the scene, because the moment utilization comes into the scene, it presupposes that the allotment has conferred a right upon him. Otherwise, how do you explain the reversion there?
My understanding is yes, my lord. Yes, the word used here is utilizing. Utilizing.
No. Utilization will be only. A person can utilize only when you give some meaning to the allotment.
Yeah, my lord.
You are saying that the allotment has no relevance. It is merely an approval by the government.
Okay, allotment has relevance, so.
It's merely an approval, because when the settlement rules of year does not speak anything, it is merely an approval. When the approval has been given and the DC has not given the allotment, a settlement, so no rights is accrued upon him.
Right, right, then include upon him only to the extent of. using the
16. Only 16, nothing more than that.
So, because rule 18 doesn't. That's what I was about to find out.
This is a wasteland. This land is a wasteland. So if this is a wasteland, because it falls within 2B, so under such circumstances, no rights are accrued upon him except 16. So therefore, when the right is not there upon him, the deputy commissioner could not have, on the basis of certain facts that the rights are accrued upon him, have issued the notice.
Rights, my lord, has include upon him, who, my lord, so far, as my lord, using the land.
No. That is not the tenure of the letter. The tenure of the letter is the rights are accrued upon him on the basis of an allotment. And as such, the basis of the entire communication is wrong, has to be set aside. Okay, enough. No, this has to go. Yeah.
They have accepted everything. There's an order of the code. Dated 14.
I
IA 381 of 2007. Already
14.6, page.
This is.
14.6 to Mr. B.K. Bhagavati, it is stated that applicant had been occupying a plot of land in one. So it is the case of land that out of the land which are in occupation of 18 lots of land accordingly and agreed to by the land undertake certain construction over the remaining and giving aside area which has agreed upon the earlier information plan to extend the applicant is allowed to area of required. Yes, what do you mean to say? How are you constructing? Are you constructing?
Some hand was given, that is the problem.
And how the permission has been given by the authorities without the ownership?
I was for submitting, whether it is investment allotted.
No, we have to interfere with this. They can't construct. The right to construct will also depend upon the right, having a right over the land. They don't have a right. How can they be allowed to construct on government lands?
Subject to utilization, allotment whether it is subject-
Again, utilization does not come into the scene because the right has not been conferred.
Now, if proposal-
Enough.
whether a proposal-
We'll interfere with the construction also.
whether-
No, enough.
That land can be allotted, definitely the
There are no rights have conferred upon them on the basis of the allotment. That is your submission, will record it.
unless a particular person is.
No, Mr. Borpuzari, enough.
Purpose of the land.
Anything else you argue before the division bench. The instant writ petition has been filed by the petitioner challenging the notice dated 28/10/2013 issued by the Additional Deputy Commissioner, North Lakhimpur, whereby the petitioners were directed to vacate their possession over the land belonging to the respondent number 4. On the basis yes, on the basis that the said land have been allotted in the name of the respondent number 4 by virtue of the government letter number RSS 102/2012/34 dated 12/6/2013. The facts which arises for consideration before this court is that it is claimed by the petitioners that the father of the petitioner number 2, late Sriram Singh, was working at Ananda Tea Estate, PO Pathaliapur in the year 1960. He occupied, the father of the petitioner number 2 occupied a government land measuring 18 letters by erecting a thatched house. The said land was situated within the North Lakhimpur town, ward number 6. On 1st of June 1970, late Sriram Singh was appointed as the organizer of Assam Sa Mazdoor Sangh, that is the respondent number 4. Thereupon, the father of the petitioner constructed the office of the respondent number 4 in the adjacent land covering 3 kathas, and the said office had been functioning under the guidance of the father of the petitioner. On 17/5/2010, the father of the petitioner number 2 expired. Thereafter, on 20/11/2010, the president as well as the secretary of the respondent number 4 issued a notice to the petitioner number 1 to vacate the premises. The petitioner number 1 submitted her reply on 1/12/2010, stating that the said land which was occupied by the petitioners does not belong to the respondent number 4, and the construction has been made by the husband of the petitioner number 1, and the land was never allotted to the respondent number 4. It further reveals that on account of various disturbances being caused by the members of the respondent number 4, a proceedings under section 107 of the CRPC was also initiated against the members of the respondent number 4. Finally, the matter was brought to the notice of the respondent number 3, that is the Additional Deputy Commissioner, North Lakhimpur, on the basis that the respondent number 4 had filed an application for allotment of the land in their favor. The petitioner thereupon approached the Additional Deputy Commissioner, that is the respondent number 3, for adjudication, and the respondent number 3 visited the disputed land and asked the executive members of the respondent number 4 for relinquishment of the demands of the 18 lectures of land which have already been occupied by the petitioners. It is the further case of the petitioner that the members of the respondent number 4 went on causing disturbance in the peaceful enjoyment of the disputed land. Finding no alternative, a legal notice dated 13/9/2011 was issued to the President and Secretary of the respondent number 4 for not causing any disturbance to the peaceful possession of the petitioners in respect to the 18 lectures of land. It is also the case of the petitioners that the petitioners have been regularly paying the land revenue up to 2012-13 to the Mozada of the Lakhimpur Moza. The Circle Officer, North Lakhimpur Circle, had also issued a certificate certifying that the petitioner number 1 is occupying 18 lectures of land covered by DAG number 275 under BDJ number 357, Lakhimpur Town, first part under North Lakhimpur Revenue Circle. Pursuant thereto, the petitioner number 2 submitted an application under the Right to Information Act 2005 regarding allotment of the government land in favor of the respondent number 4. The respondent number 3, by the communication dated 28/5/2012, informed the petitioner number 2 that the proposal has been received from the Circle Officer, North Lakhimpur Revenue Circle, for reservation of a plot of land measuring 0 bigha 3 katha 0 lesa, covered by DAG number 275 and 276 of North Lakhimpur Part 1 map under North Lakhimpur Moza in favor of the respondent number 4. This document has relevance, taking into account that the proposal for allotment of the land to the respondent number 4 was only 3 kathas of land and not more than that. Subsequent thereto, on the proposal was only in respect of 3 kathas of land, and thus said proposal have been approved by the SDLAC North Lakhimpur meeting held on 27/2/2012. Subsequent thereto, on 19/10/2013, the respondent number 3 issued a notice to the petitioner number 1 to appear before him on 28/10/2013 in view of a complaint lodged by the members of the respondent number 4 regarding encroachment of land. Thereafter, the petitioner number 1 appeared before the respondent number 3 but no hearing took place. However, the respondent number 3 by the letter dated 28/10/2013 informed the petitioners that they were illegally possessing land belonging to the respondent number 4, as the land had been already allotted to the respondent number 4 by letter dated 12/6/2013, and therefore they were required to vacate the said premises within 7 days, and the notice be received and 7 days. The same notice was received on 4/11/2013. It is under such circumstances that the petitioner has approached this court seeking the relief for setting aside the impugned notice dated 28/10/2013, seeking the relief for setting aside the impugned notice dated 28/10/2013, as well as the order of allotment dated 12/6/2013 issued in favor of the respondent number 4, and it has also been prayed for that the petitioners have also sought for the relief that the impugned notice dated 28/10/2013 issued by the respondent number 3 should not be given effect to, and to enable the petitioners to stay in the said 18 letters of land possessed by them covered under DAG number 275 under BDJ number 337, North Lakhimpur First Part Town under North Lakhimpur Moja. The said petition was filed on 7th of November 2013. This court, by an order dated 11/11/2013, issued rule, and in the meanwhile, directed that the impugned notice dated 28/10/2013 issued by the Additional Deputy Commissioner North Lakhimpur be stayed. The same interim order has been continuing since then till date. This court, however, finds it relevant, before taking into account the pleadings of the respondents, that an application was filed by one Sanjit Kanti representing the respondent number 4. With a prayer to vacate the interim order dated 11/11/2013. This court disposed of the said interlocutory application by an order dated 14/6/2017. Thereby modifying the order dated 11/11/2013 to the extent that the applicant is allowed to carry out the required construction over the remaining portion of the land by leaving aside the 18 letters of land under the occupation of the petitioners. Next. This court further finds it. The records further shows that the area is a rural area.
In town.
So he'll be entitled to 1 kata 10 acres of land. Allotment,
He has land.
not necessary. She doesn't have in the urban areas.
Urban area, yeah.
Where?
That's what we put down. That should be happy.
You apply for allotment of that land. But you have asked for setting aside, no? The record reveals that the respondent number 4, that is the Assam Sam Mr. Son, filed an affidavit in opposition on 12/2/2014. The same affidavit was filed through the secretary, North Lakhimpur branch of the respondent number 4. In the same affidavit, it was mentioned that the house in which the petitioners claimed to be theirs had always been used as the office by the respondent number 4, which has been in possession, use, and enjoyment of the same, and the adjoining land surrounding it since the year 1959. The father of the petitioner, the father of the petitioner number 2, late Sriram Singh, was serving as an employee of Ananda Tea Estate, which is situated about 30 kilometers away from North Lakhimpur till the year 1970. At that time, he was serving as the in the Ananda Tea Estate. He was living in a quarter provided by the said tea estate. The late Sriram Singh was appointed as an organizer of the Assam Sam Mazdoor Sangha, North Lakhimpur branch, from the 1st of June 1970 by an office letter dated 28/5/1970, in which letter the address of Sriram Singh appears as Ananda Tea Estate PO, Pathali Pam, which is 30 kilometers away from the current place of residence of the petitioner, which they claim as their own. The same letter was duly received by late Sriram Singh, and as such, it is the contention of the respondent number 4 that the claim of the petitioner is unfounded, in as much as admittedly they are in occupation of government land, and admittedly they are occupiers of government land measuring 18 lechas by erecting a thatched house. You are admitting this line?
No.
You are admitting this document. The claim of the petitioners is unfounded, in as much as admittedly they are occupiers who have occupied a government land measuring about 18 lechas by erecting a thatched house. What do you? You are admitting this document.
Or not. At that time I was not here.
And then it is very easy to put it. In the said affidavit in opposition by the respondent number 4, it is, however, it is also admitted that the petitioners were occupiers. Further to that, it is mentioned that the father of the petitioner number 2, after being appointed as an organizer by the office, he stayed in the rented house in ward number 7 of North Lakhimpur town. Thereafter, it was also stated that the office of the ACMS of the respondent number 4 existed in the house situated on the western side of the plot of land measuring approximately 12 acres, where the petitioners are now claiming as their own. Further to that, it is also stated that the new Assam type building was constructed on the eastern side of the plot of land. The office of the ACMS North Lakhimpur branch was shifted there in the year 1985. It is the specific statement made in the paragraph number 5 of the affidavit in opposition that the petitioner number 2's father was allowed to live in the old Assam type house, which was also built by the respondent number 4. The further facts, the further statements made in the affidavit in opposition shows, filed by the respondent number 4, so that after the death of late Sri Ram Singh in the year 2010, his family members were allowed to stay in the old Assam type structure of the respondent number 4 for 6 months. And only after the expiry of 6 months, they were asked to vacate the said premises. It was further mentioned that in the plot of land measuring 3 katha 12.5 acres, was allotted by the government in favor of the respondent number 4 on 12/6/2013. Possession thereof was duly handed over to the respondent number 4 on 2/7/2013, as reflected in the handing over taking over report dated 2/7/2013, issued by the Circle Officer, North Lakhimpur Revenue Circle. The same affidavit in opposition, filed by respondent number 4, various documents have been enclosed. From a perusal of Annexure B, it reveals that the Deputy Secretary to the Government of Assam Revenue and Disaster Management Department had issued a communication on 12/6/2013 informing that the Governor of Assam was pleased to order for allotment of Sarkari land measuring 3 katha 12.5 acres covered by DAG number 275 bracket part Kho and 276 part Kho of North Lakhimpur town first part under Lakhimpur Moza in favor of the respondent number 4, subject to utilization for the specific purpose within 3 years, failing which the land so allotted will automatically stand cancelled and reverted to the government in the Revenue and Disaster Management Department. The land records were directed to be corrected accordingly after handing over the possession of the land to the concerned authority. Pursuant to the said order of communication dated 12/6/2013, the circle officer, the additional deputy commissioner, Revenue, Lakhimpur, North Lakhimpur, issued a communication to the circle officer enclosing the communication dated 12/6/2013 and with a direction to correct the land records accordingly at the earliest. The circle officer, North Lakhimpur Revenue Circle, was also requested to submit a copy of the handing and taking over certificate to the additional deputy commissioner, Revenue, Lakhimpur, to the additional deputy commissioner and Revenue, North Lakhimpur. Pursuant thereto, on 2/7/2013, the circle officer, North Lakhimpur Revenue Circle, handed over the possession of 3 katha 12.5 lectures of land covered by Dag number 275 part 4 and 276 part 4 of North Lakhimpur Town part 1 first part map under Lakhimpur Moza on 2/7/2013 to the President Secretary of the respondent number 4. It is also reveals from the said document that the President the Secretary of the respondent number 4 have also categorically mentioned that they have taken over the possession of 3 kathas 12.5 lectures of land covered by the said Dags above mentioned. This court further finds it relevant to take note of an affidavit in opposition filed by the respondent number 2 and 3. In the said affidavit in opposition, it was mentioned that the father of the petitioner did not, petitioner number 2, did not occupy the land in question in the year 1960. It was categorically stated by the additional deputy commissioner that the father of the petitioner encroached upon after the allotment proposal was made in the name of the respondent number 4. It is, however, pertinent herein to mention that the father of the petitioner admittedly expired in the year 2010. And it is not known under what basis the additional deputy commissioner, Revenue, North Lakhimpur, had made that statement. It is further seen from paragraph number 6 of the affidavit filed by the respondent number 2 and 3 that the respondent number 4 had submitted a petition number 24.BC 2012/140-3 dated nil for allotment of a plot of land in the name of the institution. On the basis of their application, the circle officer North Lakhimpur submitted a proposal for allotment of the plot of land measuring 3 kathas covered by Dag number 275 and 276 of North Lakhimpur town, first part map in the name of the respondent number 4 by the communication dated 7/2/2012. The said proposal for allotment of the plot of land measuring 3 kathas was received in the office of the additional deputy commissioner, revenue, from the office of the circle officer, North Lakhimpur Revenue Circle, by way of a communication dated 27/2/2012, which was approved by the Subdivisional Land Allotment Committee meeting held on 27/2/2012 itself and was submitted to the government for necessary approval. It is further mentioned that respondent number 4 again submitted a petition for revision of the proposal made in favor of the respondent number 4 in respect of the land in question. And accordingly, the circle officer was directed to verify the matter and submit a revised proposal accordingly. Okay, I'll come back.
This further mentioned that the respondent number 4 even submitted a false revision of the proposal made in favor of the respondent number 4 in respect or all.
And accordingly, the circle officer not looking to was directed to verify the matter and submit a revised proposal. The circle officer not looking to Revenue Circle thereafter submitted a corrected proposal for allotment of a plot of land measuring 3 katha, 12.5 leshas, covered by Dag number 275 and 276 of North Lakhimpur town part, first part map in the name of the respondent number 4 by the letter dated 10/9/2012. Which was approved by the Subdivisional Land Allotment Committee meeting held on 19/10/2012 and was submitted to the government for according the necessary approval. The government approved the revised proposal for the said plot of land measuring 3 kathas, 12.5 lechas of the land in favor of the respondent number 4 by the communication dated 12/6/2013. Further to that, it was mentioned that the additional Deputy Commissioner Revenue, upon receiving a complaint from the respondent number 4, that a part of the scheduled land, which was allotted to the respondent number 4, was encroached by the petitioners, a meeting was called wherein the petitioner as well as the respondent petitioners and the respondent number 4 were present on 28/10/2013. The respondent number 3. Now, in the said meeting, it was agreed to that the petitioners would vacate the encroached land within 7 days from the date of the said meeting. And for that purpose, the notice was formally issued to the petitioners as per the minutes of the said meeting dated 28/10/2013. It further reveals from the records that the petitioner had filed affidavit in reply to the affidavits filed by the respondent number 2 as well as the respondent number 4. In the affidavit in reply filed to the affidavit in opposition filed by the respondent number 4, the statements made in the affidavit in opposition were denied. To the extent that it is the petitioner's predecessor in interest who had constructed the office of the respondent number 4 and also had constructed the residential house by erecting a thatched house which was altered to Assam type house. It was further mentioned the statements made in the affidavit in opposition to the effect that the plot of land which houses the offices of the structures, meeting hall, garage, guest house, well, etc. of the respondent number 4 are bounded by brick wall with grills of iron gate on the southern side, built about 18 to 19 years ago. And further, in the middle of the campus, there is a big olive tree. It was denied that the land measuring 12.5 lectures, which the petitioner claims as their own, falls within the area. In the affidavit in opposition, affidavit in reply filed to the affidavit in opposition filed by the respondent number 2, the communication issued, the undated communication issued by the president as well as the in charge secretary of the respondent number 4 was enclosed. From the same communication, it reveals that the respondent number 4 applied for allotment of 1 bigha, 1 katha, 5 lectures of land of Dag number 275 and 276. And unfortunately, only 3 kathas of the land were shown in possession of the respondent number 4. And the allotment was only made for the same. The communication dated 10/9/2012 issued by the circle officer to the Deputy Commissioner Lakhimpur, North Lakhimpur, for correction of the land allotment proposal was also enclosed to the affidavit in reply. Further to that, another communication issued by the additional Deputy Commissioner Revenue to the Deputy Secretary to the Government of Assam Revenue and Disaster Management Department was enclosed, whereby the corrected proposal for reservation of land measuring 3 big kathas 12 by 3/4 lechas covered by DAG number 275 bracket part 4 and 276 part 4 of North Lakhimpur town first part map under Lakhimpur Moza in the name of the respondent number 4 was submitted. I've heard the learned counsels for the parties. This court have duly perused the materials, the pleadings, as well as the materials on record. In the backdrop of the above, let this court therefore take note of the respective contentions made by the parties, submitted by the learned counsels appearing on behalf of the parties. Mr. S. Dr. the learned senior counsel appearing on behalf of the petitioner submits that the respondent number 3 had no authority or jurisdiction to issue the impugned communication in as much as it being a private dispute between the petitioner and the respondent, petitioners and the respondent number 4. The respondent number 3 could not have entered into such private disputes. And as such, the issuance of the said notice, impugned notice on the face of it, is nothing but an abuse of the process of the court, the process of law. Are you challenging the allotment? You have not gone for allotment. Are you going for allotment? Yes. The learned counsel appearing on senior counsel appearing on behalf of the petitioner submits that as the petitioner's predecessor in interest, as well as the petitioners presently have been occupying the land measuring 12.5 lechas or 18 lechas. The petitioners have a right to seek settlement in terms with the then existing policy, land policy of 1989, as well as the present Land Policy of 2019. In view of he further submits that in view of the pendency of the reinstatement petition, the petitioners have not applied for such settlement. Mr. Datta, you would like to endorse his submission to the effect that allotment is not a settlement and as such no right has been conferred?
Their submission.
No, you will also like to endorse that. It may help you. Yes. He further submits that the respondent number 4 have only been allotted a plot of land measuring 3 kathas 12 by 3/4 lechas. And as per the provisions of the Assam Land and Revenue Regulation 1886, bracket for short, the regulations of 1886, allotment is nothing but an approval of the government to a land allotment proposal. And as such, no rights have been conferred upon the respondent number 4 on the basis of the said allotment, unless the said allotment is followed up by a settlement order, as well as correction of the record of rights, which have admittedly not been done in the case of the respondent number 4. Anything else?
Terms of the making, go to the last away, union period of the of that. The decision of accepted power, is that power is not in existence.
Not necessary. I've already recorded.
Yes, they lost.
Mr. Arbu Pujari, the learned standing counsel of the revenue, drawing the attention of this court to the provisions of Regulation 6, Section 6, (9) and 11 of the regulations of 1886, submits that it is only the landholder, settlement holder, proprietor of a land who has a right over the land. Referring to clauses, the subclauses A, B, C, and D of Section 6 of the regulations, Mr. Borpujari submits that to have a right over the land, the respondent number 4 has to come within the ambit thereof, the ambit of them. The lyrics standing counsel further referring to the powers of the state government in terms with Section 12, 13, and 14, read section 27 and 29 of the regulations of 1886, submits that the settlement rules have been framed is further drawing the attention of this court to Rule 15 of the settlement rules. He submits that merely on the basis of a possession, however long, a person has no right to remain right over the land. The learned standing counsel further drawing the attention to Rule 16 of the regulations submit that unless and until a lease, which is in the form of a patta, have not been issued to the respondent number 4, the respondent number 4 has no right over the land and has also no right to remain in possession. He therefore submits that the learned counsel, however, submits that in view of the communication issued by the additional deputy commissioner to the circle officer on 1st of July 2013, and the possession on the basis being handed over on 2nd of July 2013 shows that the respondent number 4 have been permitted to remain in possession of the land pending issuance of the lease. The learned standing counsel therefore submitted that taking into account section 6 and the other provisions, the respondent number 4's right at present is only a right to occupy the land in question and nothing beyond that.
You can repeat the tenor of that, or allotment with that. It is 12:6 or something like that.
That I read. Mr. B.K. Bhagavati, the learned counsel appearing on behalf of the respondent number 4, also endorses the fact that the respondent number 4 have only been allotted the said land and there has been no settlement made till date in favor of the respondent number 4. He therefore submits that as of now, as for the present, the respondent number 4's right is limited to remain in possession pending issuance of lease pursuant to the approval so granted by the government in the form of an allotment dated 12/6/2013. The learned counsel for the respondent number 4 therefore submitted that as the settlement has not yet been granted to the respondent number 4, the land in question still continues to be a government land. And as such, the respondent number 3 was within his jurisdiction to issue the notice stated, the impugned notice stated 28/10/2013. I've heard the learned counsels for the parties, and upon hearing the learned counsels for the parties, and this court finds it relevant. Parties. 2 points for determination arises for consideration. Number 1, whether the respondent number 3 was within his jurisdiction to issue the impugned communication dated 28/10/2013, question mark. Number 2, what rights had accrued upon the respondent number 4 on the basis of the order of allotment dated 12/6/2013 and the possession being handed over on 2/7/2013. 3 data point. Number 3, what reliefs the parties herein are entitled to on the facts of the instant case. The point of determinations number 1 and 2 as framed herein above are interlinked. Under such circumstances, this court finds it relevant to observe and finds it relevant to take note of some of the provisions of the regulations of 1886 and the settlement rules framed therein under. Chapter 2 of the regulations of 1886 stipulates the rights over the land. Section 6 of the regulation stipulates the rights which may be acquired over the land. In terms with section 6, no right of any description shall be deemed to have been or shall be acquired by any person over any land in which chapter 2 applies, except what has been mentioned in the subclauses to section 6. That was it. Rights of the proprietor, landholder, and settlement holders other than landholders as defined in the regulation, and other rights acquired in the manner provided by the regulation. Bracket close. The bracket at the table. Subclause A. Semicolon. Rights legally derived from any right mentioned in subclause A. Bracket. Subclause B. Semicolon. Rights acquired under section 26 and 27 of the Indian Limitation Act 1877, bracket, subclause C. And rights acquired by any law, by any person as tenant under rent control, rent laws for the time being in force, subclause D. The proviso to section 6 stipulates that nothing contained in the said section shall be held to derogate from the terms of any lease granted by or on behalf of the government. Next. Section 6, 7, 8, and 9 relates to the rights of the proprietor, semi-comma, status of the landholder, how acquired, and the rights of the landholders, respectively. Before further proceeding, this court finds it relevant that for the purpose of acquiring a right of a landholder, a lease has to be granted by or on behalf of the government in terms with section 8B of the regulations of 1886. Section 12, 13, and 14 relates to the certain rule, relates to the powers conferred upon the state government to frame rules for the purpose of disposal of government land and ejectment therefrom of unauthorized occupier, comma, for allotment of grazing grounds and for allotment of lands for tribes practicing Jew or migratory cultivations, respectively. Section 15 of the Act of the regulation stipulates that no person shall acquire, comma, by length of possession or otherwise, any right over land disposed of or allotted under section 12, 13, and 14, beyond that which is given by the rules made under the section. This court further finds it relevant to take note of section 27 and 28, 29, which empowers the state government to frame rules. On the basis of the powers conferred upon the state government by virtue of section 12, 13, and 14, read with section 27 and 29, comma, of the regulations, the settlement rules have been framed. Rule 1 of the settlement rules stipulates that all powers of the Deputy Commissioner under these rules shall be exercised subject to any general or special orders issued from time to time by the state government. This court further finds it relevant to take note of Rule 2C, which relates to annual lease, meaning thereby a lease granted from 1 year only and confers no right on the soil beyond a right of user for a year for which it is given. Rule 2CD relates to a periodic lease. in the case of other than townlands, a lease granted for a period longer than 1 year. And in the case of townlands, a lease for a period of longer than 3 years. Rule 2F relates to settlement, meaning the leasing of the land at the disposal of the government, and includes the operation of survey, classification, and report preliminary to such leasing. Rule 2 confers powers of the Deputy Commissioner for disposal of wastelands required for ordinary or special cultivation or for building purpose. So the Deputy Commissioner has the power to dispose of such land by grant, lease or otherwise in the manner and subject to the conditions set forth in the rules following rules provided in the settlement rules, provided that the Deputy Commissioner may expressly reserve any such land for settlement. Rule 3 relates to the power delegation of the powers of the Deputy Commissioners. And in terms with subclause 1 of Rule 3, no officer of lower status than a sub-deputy collector shall pass final orders to issue a periodic lease or to grant settlement. Provided that the sub-deputy collector may not exercise such powers if the land in question exceeds 12 bighas or such other area as may be prescribed by the state government by general or special orders from time to time. Rule 15 stipulates that no person shall have any right to settlement merely because he is in occupation of land not included in any lease granted by the state government either to himself or to any other person. Rule 16 prohibits any person to enter into possession of wasteland in any area until a lease has been issued to him or otherwise a written permission by the Deputy Commissioner has been granted to him pending issuance of such lease to enter into possession. Rule 18 empowers the Deputy Commissioner to eject any person from the land over which no person has acquired the right of a proprietor, landholder, or settlement holder. A perusal of Rule 18.2 stipulates that when such person had entered into possession of government khas land or wasteland, or estate over which no person has acquired the right of a proprietor, landholder, or settlement holder, or any land that has been previously been reserved for roads or roadside lands, or for grazing of village cattle, or for other public purpose, or has entered into possession of land from which he had been excluded by general or special order, and when further there is no bona fide claim of right involved, it will underline to it. Such person may be ejected or ordered to vacate the land forthwith. And the deputy commissioner may sell, confiscate, or destroy any crop raised or any building or other construction erected without authority on the land. Rule 3A relates to other cases of ejectment which shall be preceded with the publication of notice in the manner prescribed below, requiring the occupant generally to vacate the land specified in the notice within 15 days from the date of publication of the notice on the land concerned or in a prominent place in the vicinity thereof, and to remove any buildings, houses, fences, or crops, etc., which may have been raised on such land. A conjoint reading of Rule 18.2 and Rule 18.3 shows that in a case where there is an existence of a bona fide claim of right, Rule 18.2 cannot be exercised. In the backdrop of the above, it would therefore would seem Mr. Bordujari, where is the approval required? Under what provision? Why is the government giving that allotment?
That is person not there, not in the regulation.
So unless you have an executive order for that, then you can bring in view of one. Rule 1 you can bring in, unless you have an executive order, you cannot. So the allotment is useless. Huh?
This appears to be a preceding exercise. This appears the spectrum of allotment of land is a preceding exercise.
On what basis? So we will observe it that it is from a perusal of the above provisions. It is not seen under what provisions of the regulations of 1886 or the rules framed therein under. The requirement of an approval from the state government or allotment of the state government is required. unless there are executive orders supplementing the settlement rules, making it a condition precedent for allotment, for an approval or allotment by the state government prior to the settlement. This opinion of this court is based upon a reading of Rule 2 of the settlement rules, which empowers the Deputy Commissioner on his own to grant, lease, or otherwise dispose of wastelands in the manner and subject to the conditions set forth in the settlement rules. The proviso to Rule 2 only requires the previous approval of the state government. In respect to lands in an unclassified state forest containing trees as declared as reserve trees under Section 32 of the Assam Forest Regulation 1891. Therefore, the allotment which has been made as conveyed by the communication dated 12/6/2013 in favor of the respondent number 4, since any settlement being made by the Deputy Commissioner or his delegate in terms with Section 3, Rule 3, does not confer any right over the land upon the respondent number 4. Upon the land, rights over the land covered, measuring 3 kathas, 12.5 letters covered by so and so, so and so. We can read it. Dag number 275 core and 276 core. Does not convey anything. The only right the respondent number 4 has is in for occupation, oblique possession over the land over the said land on the basis of the communication issued by the additional Deputy Commissioner, Revenue, to the circle officer, North Lakhimpur Revenue Circle, and the subsequent handing over of the possession of the said land to the respondent number 4 by the circle officer, not Lakhimpur Revenue Circle. This court has also put a specific query upon the learned counsel appearing on behalf of the respondent number 4 as to whether the respondent number 4 have all these years pursuant to the allotment made of the land have paid the land revenue. The learned counsel for the respondent number 4 submits that the respondent number 4 have not paid the land revenue in as much as the lease, the settlement have not yet been issued by issuance of a periodic lease in the form of a patta in favor of the respondent number 4. Therefore, from the above analysis, it is seen that the right of the respondent number 4 over the land in question is a right to remain in possession till being evicted by the government, by the deputy commissioner. If the allotment is cancelled or the permission so granted is cancelled, the next question which arises is, could the respondent number 3 issue the impugn notice dated 28/10/2013 to the petitioners? A perusal of the said notice, which have already been referred to supra, shows that the said notice have been issued informing the petitioners that the petitioners are illegally occupying the residential premises of the respondent number 4. And the petitioners were directed to vacate within 7 days. To understand the same, the prelude to the same notice, impugn notice, is seen from the affidavit filed by the respondent number 3. At paragraph number 9, wherein it has been mentioned that on the basis of a complaint from the respondent number 4, the respondent number 3 called for a meeting on 28/10/2013, and on the basis of some agreement, and the agreement, the respondent number 3, the notice dated, impugn notice dated 28 on the basis of agreement, the impugn notice dated 28/10/2013 was issued. Therefore, it would be seen that the same notice was issued at the behest of the respondent number 4. Now the question arises as to whether the respondent number 3 could have exercised his statutory powers to do so at the instance of the respondent number 4. That too, directing the petitioners to vacate from the residential accommodation of the respondent number 4. To ascertain the same, this court finds it again relevant to take note of the affidavit in opposition filed by the respondent number 4, wherein it has been specifically mentioned that the petitioner's father, the petitioner number 2's father, was permitted to stay in the residence in the house of the respondent number 4 when he was the organizing secretary of the respondent number 4. And thereupon, after the death of the petitioner number 2's father in the year 2010, 6 months thereafter, the respondent number 4 had asked the petitioners to vacate this residential quarter. This clearly shows that it is a private dispute between the respondent number 4 as well as the petitioner. And the petitioner and the respondent number 3. Private dispute between the respondent number 4 and the petitioners. Be it as it may, this court also finds it relevant to take note of that on 2/7/2013, possession of the land measuring 3 kathas 12 by 3/4 lechas, covered by dark number so and so, pata number so and so, was handed over to the respondent number 4, and which was also taken by the respondent number 4, by its president / secretary, under their signatures. Under such circumstances, if there is any dispute as regards the possession of the land under the occupation of the respondent of the land which have been handed over, the possession of which have been handed over to the respondent number 4, is also a private dispute between the petitioner and the respondent number 4. And the respondent number 3, being a statutory authority, ought not to have entered into the said private dispute and exercised such powers of issuing a notice, the impugn notice dated 28/10/2013. This, on the face of it, in the opinion of this court, amounts to malice in fact. On the part of the respondent number 3. In as much as malice in fact, as well as a complete abuse of the process of the of the powers conferred upon the respondent number 3. Next. In the backdrop of the above analysis, let this court therefore take note of take into consideration as to what reliefs the parties herein are entitled to. As already above aforesaid, the impugned notice dated 28/10/2013 is a notice issued abusing the powers conferred upon the respondent number 3. And as such, the impugned notice dated 28/10/2013 is set aside and quashed. Next. The dispute between the petitioner and the respondent number 4, pursuant to the handing over of the possession on 2/7/2013, is a private dispute pertaining to the respondent petitioner and the respondent number 4. Further to that, as the respondent number 4 themselves admit that the petitioner are in occupation of the house standing over the land which have been allotted to the petitioners. The dispute primarily is on the basis of between the petitioner and the respondent number 4 is as to whether the petitioner are entitled to remain in possession of the said Assam type house presently under their occupation. These aspects of the matter cannot be decided by the revenue officials and has to be decided by a competent civil court. As such, this court while setting aside the notice dated 28/11/2010-2013, grants the liberty to the petition respondent number 4 to initiate appropriate proceedings before the competent civil court against the petitioners. This court also finds it relevant to take note of that the issue as to whether the petitioners could be evicted on the basis of the impugned notice dated 28/10/2013 has been pending before this court since 2013. And as such, and the parties herein have been diligently pursuing their litigations, pursuing the present litigation. This court also finds it relevant that as the petitioners are still in occupation of the Assam type house of purportedly of the respondent number 4. It is a continuing cause of action. And as such, there shall be no limitation which would bar the petition respondent number 4 to initiate any any ejectment proceedings against the petitioners. This court further, duly takes note of the submission of Mr. S. Dr. the learned senior counsel, that the petitioner, that as the allotment so made in favor of the respondent number 4 have not yet been finalized, and does not confer any right upon the respondent number 4 over the lands in question. The petitioner may be granted the liberty to file appropriate applications seeking allotment of the land under their possession. The said aspect of the matter being outside the purview of the instant writ petition, this court would not like to delve upon the same. However, the above observations made shall not preclude the petitioner to file appropriate application if otherwise permissible under law. With the above, the instant proceedings stands, the petition stands.
Make out. Gaonpura, the family tree, this has been, the certificate, this has been granted by the Gaonpura long time back, and also the draft Sita, it reflects the KP Patra 25, shows that the grandfather and the great grandfathers were the title holders of Kolbotskar, which is the recognized as the community, and thereafter the father and the petitioner have been writing the title of Kalka.
Now, how do you link the father of the petitioner with his grandfather?
Yes, I have made a mark.
Yes. You here, these orders categorically say that the petitioner and the grandfather has a connection
Petitioner and the grandfather.
on the basis of this land records. Now, these land records show only, this was done as far back as on when the father was alive. What happened to the land thereafter? Was it mutated in the name of the father of the petitioner or the grandfather of the petitioner, or was it sold? Then how do you have a link with the land records? You can't have a link with the land records otherwise.
Honiram Taluka happens to be the father of the petitioner. So from this Ramalbandi copy, the Honiram Taluka,
Where?
Hora Mohan Das, the third page.
Or Mohan Das. That is Potta number 39.
That is new.
What new?
Subsequent to original draft Sita has been, in fact, it is also part of the affidavit descendant filed by the private respondent. So the draft Sita says, KP Patra 25. Mani Kolbotskar, Sita, Rocky Kolbotskar, Mota Kolbotskar, Hore Kolbotskar. Now, Horo Kolbotskar happens to be the grandfather of the petitioner. That's your logic of the draft Sita.
Yes.
Also, if your lawsuit goes to the affidavit in opposition filed by the private respondent, it is also part of that.
By respondent number 7?
Yes.
Yes.
Respondent number 7, Annexure 7, page 18.
Page,
Page 18. Page 18, it's not the running page.
yes, page 18, I have seen it. That is 25. There, yeah, Horo, Koboto.
See,
but how do you link this with that?
Horo Koboto happens to be the grandfather.
That you are saying, everybody is saying, how? How do you say that 25 has become 39 and Horo Koimbatoor became Horo Mohan Das? How do you say that? That is why I have asked you.
Das and Koboto, yes.
Yes, no, because you see, on one hand,
Previous two generations were acting Koboto.
understood, let it be written as Koimbatoor. But if you see, kindly see, come to this document which we have enclosed. We have given it today.
Yes.
See the last document pertaining to Jamabandi of tag number, Patta number 39, 37. Now, whether 37 is 25, I don't know. But here you see Harmohan Das. Now, if it is Harmohan Das, why in the same Patta where it was already mentioned as Horo Koimbatoor, how did it become Horo Mohan Das? You see the difference. Hor Mohan Das.
Mohan or Namor.
No, not that.
I've gone
No,
down
no.
below.
See number one, which have been struck off.
Yes. Oh,
Hor Mohan Das. Why it is not written as Hor Mohan? No, Horo Koimbatoor.
Horo,
Why it is not written? You don't change the name thereafter.
yes.
Then I would have understood it is written as Horo Koimbatoor and thereafter the names have been changed. But why it is being done? That is what I wanted to know.
Yes.
You are coming up with the same thing which happened on the last occasion.
The second-
And it happens because the councils keep on changing. So this time, whom should we instruct? You and S. Sharma both.
I will come.
Huh?
I will come only to that specific. Word.
That is what I asked.
Horo Mohan.
How do you interlink
The Horo
Horo Koimbatoor?
and Horo Mohan Das.
Here the name changes. Horo Mohan Das.
The place is changed.
And when a chitta or any copy, it is there, record of rights, it has been mentioned out there. It is always written that, and if any change happens later on,
Yes.
you have to file an application for changing. You can't change the name on your own. But here, what has been struck off is Horo Mohan Das.
It is written in Dhoniram Das father's name.
Obviously. So Dhoniram
Here,
Dhoniram Das' father would be Horo Mohan Das. But whether Horo Mohan Das is Horo Koimbatoor,
one and the same.
then this is it. And whether this Patta which has come in after 25, is this a new Patta which came into existence after that? And why the name was changed? You can't change the name in this manner. This code by the order dated 7/9/2023 directed the government advocate, Ms. S. Sharma, to apprise this court as to how the authorities concerned have linked the land records pertaining to KP Patta number 25 in the name of Horo Koimbatoor with the petitioner's father as well as the petitioner. Today, Mr. S. Borua, the learned government advocate, have placed before this court a set of instructions. In the same set of instructions, it is not clear as to how the Patta number 25 became Patta number 37 as submitted by Mr. S. Borua. Further, a perusal of Patta number 37 shows the name of the petitioner's grandfather as Horo Mohan Das. which is however different from the person whose name is appearing in patta number 25. That is Horo Kolbuttar. Mr. S. Borua shall obtain the necessary instructions and apprise this court on the next date. List the matter again on day 19, 26th of September. The instructions so placed is returned on account of being incomplete. Ready.
Unitary item 14 to 16.
Oh, that one,
Yes,
6/1/2022.
yes.
That is that Boragaon land.
Was allotted to the family.
Now there are two affidavits.
One affidavit.
Who has filed?
These are the affidavit filed by the.
He is the person who have issued this.
Yes.
Let's see what does he say. I had applied to get ownership of a plot of land measuring 3 acres to the Patena of Iman of Iman. Pata number Iman pertaining to understand. Three acres to Pata bearing Patena According to the bank state from the the land No, I don't understand what is paragraph 7. What does he say? Explain it to me. You have understood? No, it's okay. But have you understood what is paragraph 7? That the land measuring 802.68 R under tag number so and so, which is the government land, and the same have already been reserved for construction of family court. But inadvertently, it goes out of my knowledge. And because of that, under a wrong notion, a request was made by so and so for correction of so and so from the government land to KP Patta number so and so. What is this? What do you mean by that?
That was has already been reserved for the judicial
No,
department.
no, forget about judicial department will come later on. The reservation will happen after you have the ownership over the land. Does the government have the ownership over the land?
No, Lordship, on that day, the question arose whether this KP Patta number 1688 and 704 is still Patta or not.
No. The question arose in view of the letter of the deputy commissioner wherein he says that Dag number 704 old 1088 new, which is the government land, comes into existence from Dag number 704,
771.
comes originated from 770 and 771 of the same village. Is it?
So, Lordship, go by that. I have a pencil mark Lordship. Mark just has two Lordship at the top. Pencil.
So 704 oblique 1105. Vote became 1688. 704 was earlier 770 oblique 771, which became 574. This is Sir Lane. And what about the other land? That is Patta number what? 730-574-771.
7. 1.4 part Lordship. Of the 59, 60, 12.
Sonor, এখন নম্বর এসব ভূদর মধ্যে পাঁচ বিঘা 2 কাঠা করতেছে There is someone looking behind. So are you saying that land which is in occupation, the land where the petitioner was an occupancy tenant, is a government land? How? How he could have got a khatiyan in respect to a government land?
It will also go by then. That 735, 74, 771. Where the tag number is reflected.
Where?
That, any problem I have mentioned there's two.
Two.
The Montpellier.
Hmm.
1959 চনৰ 1304 নম্বৰ দৰখাস্তৰ ASOৰ মহোদয়ৰ কিমান নম্বৰ তাৰিখৰ হুকুম মতে তুলনাত 27 টকাৰ প্ৰিমিয়াম আদায় ক্ৰমে 771 টাকাৰ 5 বিঘা মান লেচা জমি 1368 চনত নতুন মেধিভুক্ত কৰা হয়।
So Notun Miyadi Matam means the patta has been issued.
But thereafter also future lawsuits comes to this the serial number 1 lawsuit I had mentioned.
Yes.
There also it is mentioned as Sarkar and in the Montpellier Board lawsuit 1961 চনৰ 1103 নম্বৰ বাবে দৰখাস্ত কৰিছিল হুকুমতে এই ডাগৰ 46 দখলমুক্ত কৰা হয়। In between for a period of 1 or 2 years that document must be required.
No. You are saying again, if you read it, 1961, 62 sonor.
1103 দরখাস্তর ASOর 27 নম্বর হুকুম মতে এই ডাগর 40 বিঘা জমি
At Sokot Ali. Who is Sokot Ali? Anybody? Sokot Ali. Sorifi. Sokot Ali. Asim Ali. Dokhol Bukto Kora Hoy. Dokhol is different. This is Dokhol Kar. They are Dokhol Kar. This has nothing to do with that. But they know this is a Sorkari land. But how do you say this? So you see what has happened out here, 730, 574, 771 have been already made Miyadi. If it is a Miyadi plot of land, it has already been allotted.
That document should be required.
What document is required? So this is the land which is already been made Miyadi.
But there
And how do you bring then, are you saying, and how much is the land? Why did the deputy commissioner write all these things? Here the land is only
5 biঘা
even Matri goes 5 biga 2 katha eklasa
5 biঘা 2 কাঠা 7
7 less. 5 bigas 2 katha 7 lesses have already been Miyadi. So it is no longer Sorkari. And how from there you are saying that is to be a Sorkari? Once you have already granted the allotment out there on the basis of some order, unless you cancel this order, do with some manner, you can't make it Sorkari.
That is in between lordship that because it is the order of 5960.
So
In 5960.
it is your burden to show that if this land is there, so therefore the question arose as to whether, because your deputy commissioner writes it otherwise. Your deputy commissioner writes that these from this land, that 802 that comes 802 hours comes in from those government lands. That is what you are writing.
But from these documents, they
Mr. Borpujari, Only see here. This is the plot of land which have been, it was maybe a Sarkari or whatever maybe, but it was made Miyadi. Meaning thereby, there is a settlement which has been done. Out there, the petitioner herein, petitioner's father herein was an occupancy tenant. There cannot be any occupancy tenant, as I know, under the 71 against government. So the concept of occupancy tenant, if he is there, it has to be in respect to a Miyadi land.
As per section 23-24.
Absolutely. Therefore, the ownership has to be given thereafter, because then only he will have a right. Because the concept of the occupancy tenant handing over the proceeds or 10% of it to the government does not arise. So once he is the occupancy tenant, that has to be a particular Miyadi land. It is a simple case which have been made complicated by the learned Deputy Commissioner. And he himself says in his affidavit, I don't understand what the head or tail he has stated in paragraph number 7. Be there as it. My basic question is whether the government dial of 802 hours would not have arisen from that private land. It can't happen. That original land which was there may have been settled to somebody. The settlement then where they are the occupancy tenant. But to say that to be government land later on, you can't say once the Miyadi has been done.
Only when there is any access, there is any ceiling for cities. Only then.
How can there be a ceiling proceeding of 5 bighas, 2 gutters, 7 lessons? That is concept, the concept is gone. So there cannot be a ceiling. And if it is a ceiling out there, then it will go as per the, there has to be the draft statement under section 7, which has not been done. So that doesn't arise. So how would this land, which has been given, have been taken away? The only thing is as to whether that land of 770, which they are saying, this particular this document, which forms the, on the basis of which the petitioner is occupying, is a part of the government land or not? All along the government was holding, no, it is a government land, which have not his land, other land, which have been allotted to the district judiciary. It's a government. It is only the deputy commissioner who makes the confusion, and he doesn't know what he has written. See the language. That your deponent respectfully begs to state that a land measuring 802.68 R under dark number 704 old/1068. 1088. What is this 1088? Where does 1088 come in? My goodness. And he signs it also. This is the manner in which which is the government land. And the same has been reserved for construction of the family court, but inadvertently it goes out of my knowledge. And because of that, under a wrong notion, a request was made to the commissioner and secretary for correction of dark number 704 old/1016 area from the government land to the KP Patta. What does it mean? You understand anything? You understand? No. I think the best way is to hear it from the horse's mouth. What does he understand?
The burden parcel of that allocated to family court. Is it a set?
He has to only clarify as to whether that part of the land is a part of the government land or the land which have been acquired or taken over and the petitioner has been thrown out. Is the petitioner has been thrown out from a government land or a patta land? If it is a patta land, the petitioner is entitled to compensation. If it is not a patta land, Government land, the petitioner may not. He may be at best entitled to some jirat if he had, nothing more than that. This simple thing was going on all along, except when the deputy commissioner writes this letter. And this is why the problem arises. He categorically says that this dark number government land arises out of that land, which 100% couldn't have been, because the total land of that 7771 is 5 bigas, 2 gatha 7 lesser. Couldn't have been. 802 ours is too big a land.
So therefore, madam, I made that submission. Perhaps if any civil procedure is there, we do not-
Ceiling proceeding, where can it be for 5 bigas, 2 gatha 7 lessers? There cannot be a ceiling proceedings for that.
There may be a situation, because the petitioner, the block of land, which is the pata land, which is the pata land, they may accept, but apart from that finding of, we may have some other land, madam. If everything to more than 50 acres, but and the joinery, right, but see, imagine, why is it-
If that is there, then section 16 will come in, where the petitioner's right will acquire. Another big problem for the state.
this is actually for that. We in that situation, perhaps there might something. The land
The
is-
deputy commissioner still doesn't understand. The best was, therefore, this court directed the review commissioner and secretary to file a affidavit. Why they have not filed?
There also I made it, and you are getting on to, madam.
No, forget about that. The commissioner and secretary asked him to file the affidavit.
They are now taking up the matter with the deputy commissioner department itself is confused.
No, the department let it be confused. I'll pay him the compensation for the lands of how much? 3 biga 2 gatha? At 50 lakhs, no? Per gatha? Compensation. 50 lakhs into 3 bigas will be 50 into 50. 7.5 crores plus another. It goes.
What is that?
It goes. No, directing the department doesn't make sense, because this court had directed. Then also you have come up with this type of affidavit which nobody understands. And again he admits, only see paragraph 5. See paragraph 5 what he writes. I have cornered the issue last time only and made it very simple, which has been made complicated by you.
Some pointed for it, and let the deputy commissioner final affidavit clarifying those things.
That is what I have said in my earlier order. I went to the extent to say that the deputy commissioner does not know the head and tail of the. I have asked the commissioner and secretary revenue to file an affidavit. You file your affidavit, nothing doing. This affidavit is doesn't explain anything. No, you see, you have a copy of it. You see the last portion. Further, the land where the petitioner was evicted in the year 2014 from DAG number 704 old 1688 was originated from DAG number 770771 of same village. Now you kindly see. This was the very land. Yes, true. You have number 1? Give it to him. No, you kindly come to number 1. You see, 770771 was the. And from there, this is 704.
704.
Then you see the area 7890 point so and so. Okay,
3 bighas, 3 bighas, 2 bighas.
what 3 bigger to kotha? Where?
But ASO Mohodo, Upu Mote, 771 number double. 3 bighas, 2 bighas, donate.
No, this is Dakholkar. We are not concerned with Dakholkar. Dakholkar is different. Dakholkar is different from anything. Dakholkar is there in the, you don't find it in the regulation, you will find in that particular rules. A concept of a Dakholkar. Dakholkar doesn't have any rights. He's only occupying. Those people who are there in the government, that Kalaparland. Did you get the judgment? I've given the copy to you to be given. Okay, anyway, so those are Dakholkar. They may be there paying Tozi, and all these things. So these are Dakholkar. They have not been given. Whereas, therefore, this is the land 89034. This is the area. So this land was 77071, which became 574. Okay. Now these 574 then became this. From 574,
574 becomes 730, yes.
no, from this, these 770, 771, which became 570, became 704.
704, yes.
Now, because here on the left-hand side, it is the new one. New one. So it became 704. Then you see these 704 and 1105, which were then made 1688 new, became the Sarkar. Okay, from there. So this is there. Now here, the other document at number 2. This is 574, which became 771, became 930. 730. This 730 had 5 figures, 2 kathas, 7 lectures. And this was made Sarkari. So how does 730 has a connection with 704/1688?
And in the second phase of in the second remark, people find that period was
Huh?
the identified interest matters of the principal and it's ASO order 102 number of course. And if Upu Mote C BN Bogo had the call. Kotian or from Korahat. So Kotian has been installed.
You are eating ASO Mohoday, AXO number one, Mohoday, 3 billion. Yes, this is it. So this is this land. So this land is a patta land. What is this patta which came into existence? That is that patta where they have got it. That is patta number. Yes. You see that patta is different. That patta is 730 new, 574, 771 old is patta number 135. So that became a patta 135. Now, where is that patta 135? You must be having a trace map. Now, whether that patta of 135 coincides with this will be seen from the trace map. But that is what, the moment you look into this as to whether this patta number 135 is coincides with that government law is the question. You have to find out this patta somewhere. And this is a land which happened recently. There has been a settlement operation. So this land will be, maybe at that point of time, but this land has recently been settled. And has been some new settlement number has come in. So these things needs to be found out. It is a simple thing. So I will say that I will not explain further. And if you don't understand from there and you can't explain it to your people, then I have, the only thing is pay 8 crores. I am not going to explain. I have explained too much. You explain to your people. Hmm. Hmm.
But down below, kindly see, it may be mentioned here that a letter has been sent to the deputy commissioner so and so 17. Taking clarification information regarding the point S. If the land where the petitioner Gurubli Gurguha has applied for ownership land has been allotted to judicial department. That was the query coming from my road. It was not clear as to however why.
And the deputy commissioner does not, because he has caused the problem. Have you seen that letter of 16-1? No. Have you seen that letter? This is the problem. Show him that letter. He makes all the problems out there. Nobody had the problem. See the last paragraph of that letter.
The resettlement operation of number 704, which is under higher official or the petitioner. Therefore, you are requested to find the effort necessary exposure for connection of from government to 50% and initiation of financial aid. How can
And previous paragraph, see there.
but as the matter is I put and finally, earlier order, court has mentioned that the petitioner is legally recognized tenant of the above mentioned schedule. Further than why the petitioner was evicted in the year 2014 from that number 704 of village Kochi, Goragaon, was originated from old that number 772, where the name of the petitioner was recorded as a tenant.
That is what I am saying. There, your people have caused this problem. Was the name of the petitioner was recorded again as per the provision of so and so, the recorded tenants are eligible for so and so. See? देखो. Huh? Personal appearance. Personal appearance can't help it because I know from a fact that what he writes out here in the affidavit also, I have lost my mind or something. What did you use the word? The deputy commissioner uses this word. It goes out of my knowledge, and because of that, under a wrong notion, a request was made. See, this is the word of a deputy commissioner who is the head of the establishment. Huh? Mr. Sharma, ask your deputy commissioner to see the, you're asking your deputy commissioner, no, ask any ADC. They may know better. Ask the ADC to see the trace map. And also see the record of rights. The record of rights also will include whose names are there. These are draft cheetahs out there. And you see, from draft cheetah, if it has to come to a cheetah or anything has to, or any tag is taken out, it will be circled and taken out. And the one which is being circled out from a particular tag out there is circled out. Then if that circled out, a patta has been issued in respect to that, which will go out, and therefore it is maintained in the records that the moment the circle is out, that tag is no longer there. In that tag, because in a patta there may be various tags, and the moment you ask for a partition, you must have done it in your own house also. Entire area there is one tag. You may ask for one patta, one tag, and you may ask for a partition. And how do you know that your partition land has come from that tag? there will be a circle mark out there that this is the dag. From there, you can know from the record of rights how to go to the other dag and find out, yes, this is the dag, how it happens. So under such circumstances, if you see the particular Jamabandi as well as the Sita of these particular dag, which came out pursuant to these 5 bigas, 2 kathas, 7 lesas being brought out, you will find out what is the next dag which has happened and what is the patta number for that. Because this has been, this document, the fallacy of your deputy commissioner is this. Once a patta has been issued, it cannot remain here as 730-574-771. It could not have been. It has to be a separate dag number, a separate patta number. Once a separate dag number, separate patta number has been issued, then from there you will find out. From here, you have to see what has happened to after this, what order has been passed. And also in the trace map, just look into it as to whether the government dag, if you ask your mandal, he can just find out immediately. From that mandal, you see that this is the trace map for this government land. You have to see whether that particular dag number 135 coincides with the dag of the government. If it is so, then it is wrong. Or if it is not so. Now, what has happened in these present settlement operation, if somebody is not approaching the authorities properly, I may not use so many other words, they may put these dags in this place or the other place. You were staying out there on the north of that particular thing. On one fine day, you will find your land in the south of something. Mr. Sattar knows. Yeah, no, I have seen it. There are many things which have happened from there. So one fine morning in there, then to reduce the value of a particular land, they will just take out this dag and put it somewhere else. Then the conjoint base of the land goes. Then you run after the mandals and the circle officers, they will do. It is very easy from the High Court to say, High Court, oh, this is this. No, it is not so. If you see it down below, this is how what is actually happening. Cadastral, no. You have to show, you have to verify as to this and then file an affidavit on the basis as to whether these dag coincides. This court, by an order dated 14/9/2023, had directed both the Deputy Commissioner Kamrup Metro as well as the Commissioner and Secretary to the Government of Assam Revenue and Disaster Management Department to clarify the communication dated 6/1/2022 issued by the Deputy Commissioner Kamrup Metro. So, today, the Deputy Commissioner Kamrup Metro has filed an affidavit . However, the said affidavit is not clear on the question which have been asked for, on the query so raised by this court. During the course of the hearing, Mr. R. Borpujari have also placed an instruction issued by the Joint Secretary to the Government of Assam, Revenue Reforms and the Disaster Management Department, whereby from where it is seen that on 17th of February 2022, the Deputy Commissioner Kamrup Metro was sought certain clarifications regarding, number one, if the land where the petitioner, Srimati Bulbuli Borgohain, had applied for ownership right has been allotted to the Judicial Department. Roman 2, it is not clear as to how or why the KP Patta land was recorded as government land in the resettlement operation. However, the said reply to the said, the reply to the said communication was not received by the Revenue and Disaster Management Department of the Government of Assam. The said instruction is kept on record and marked with the letter X. This court finds it relevant to observe that the question involved in the instant writ proceedings is as to whether the land covered by DAG number 771 bracket old oblique 730 new of KP Patta number 135 of village Pochim Boragao under Jalukbari Moja is included in the land covered by DAG number 704 old oblique 1688 new of village Pochim Boragao under Jalukbari Moja. From the draft sheets which have been produced, it is seen that on the basis of an order dated 21/10/1960, a plot of land measuring 5 acres, 2 kotha, 7 lechas from DAG number 771 was made was settled in favor of Hosnur Ali and Hukuna Sheikh. If the said land has been settled, if the same land had been settled, the same could not have been a part of the government land. Under such circumstances, this court directs the Deputy Commissioner of Kamrup Metro, as well as the Commissioner and Secretary, Revenue and Disaster Management Department, to file an affidavit in terms with the earlier order dated 14/9/2023, as well as the instant order clarifying the stand. To list the matter again on 29th of September 2023. Oh, 28th of September 2023. The affidavit be filed by 27th of September. The draft chita so produced is returned to Mr. H. Sharma to be produced on the next occasion. Thanks. Mark Kurusune, এইটো এটা ফাইল থাকি গ'ল দেই, এইটো কি Why? October is a better month. Then? What is that? It takes 10 minutes for the deputy commissioner to get it. Okay, 4th of October. The affidavit be filed by 29th of September. 4th May. We'll have it on 5th of October. The affidavit be filed by 3rd of October.
Seven.
Yes, what is your case? Issue a notice certiorari 1511 by the respondent directing the petitioner to demolish the alleged unauthorized portion. Yes, 1511/2001, annexure, page 52. Yes. Nobody is appealing for GMDA. Very well. Good. Tell me. You have got a stay? So it is not demolished. To demolish the unauthorized portion and to stop construction made on so and so in so and so, feeling which free to proceed with the demolition of so and so. Okay. Very well. The authority also closed examination of the existing repair is constructed and used in gross violation of the NOC dated so and so. Therefore, I so and so to demolish the unauthorized portion and stop the unauthorized use as so and so. Under remand within 5 days of the receipt of this order, failing which the GMDA will free to proceed under so and so remand. And they shall be recovered from so. Okay, now tell me, what is wrong with the order? This is your order, Mr. Bora. This is the impugn order, 1511/2013. Huh? So you have asked them to demolish it, or you are going to demolish it? You shall do it at their cost. Now, what is the transgression they have done? Whereas the NOC for building was issued on so and so for a G+1 residential building dated Iman and as per field inspection as on Iman and the documents furnished by to this Iman for NOC. There is an old deplorable RCC building of so and so which was expected to be dismantled for the construction of the approved building later. This authority sought clarification from the Iman on what basis the order was passed in the assessment sheet showing the year of construction of the as Iman. Reported that the use of deviation as alleged is found as GF is being used as ground down and the baseline floor is used as a manufacturing unit of the umbrella. Further, it is reported that on examination of the initial assessment, sheet against the building number students was found that during an semi-houses first floor with students. Something also assessment of the is longer down baseline floor this. Was confusing and the accounting regarding the variation Yes, where is your NOC? You have not enclosed the NOC. My goodness.
Page number.
ground floor and first floor. And the approved plan is this. Let us see the approved plan. How is it? Oh. Oh, on top of it, you cancel it. Page 12. Page 12. On top, you have cut it, no? So they had ground plus 2, 1. Huh? Then how are you constructing?
What is the existing lot will get in the page number 39.
Page
39 of the.
39. Hmm.
Third in the building.
Well, ground floor, HCL,
That is A plus 2 is
first floor. Huh?
A plus 3 is it.
What? G plus 3.
Yes, residential is given for residential, commercial is also there. Residential is also there.
3-story building.
Thank you.
Ground floor. Then first floor.
Third floor.
Where is the second floor?
Second. Approved third floor.
Where is it? Mezzanine floor. Commercial portion. And where? Mezzanine floor, commercial portion. It is not clear how much. Ground floor is there. First floor is there. Then mezzanine floor is there. Whereas you have undertaken the development of building without permission and required to obtain IMAN, you are therefore requested to discontinue under work and situated as so and so. And he replies to the Guwahati Municipal Corporation. Then he is a notice, then GMDA does. He replies to the GMDA. Then your reply dated so and so. In this connection, Iman received from the commissioner Iman wherein to the copy of the NOC dated Iman issued from the local customer. Yes, tell me. Okay. Thursday. You know this matter is going to go out. Thursday. The matter upon being heard at length, the learned counsel appearing on behalf of the petitioner submits that taking into account that the dismissal of the writ petition would result in demolition of the petitioner's building, an opportunity may be granted to the petitioner so that the senior counsel who have already been engaged can make additional submissions. Taking into account the above, list the matter on 21st of September 2023 at the top of the list.
Nine and 10.
Yes, Mr. Taraf. Very well, you argue the case. What is this case about? Huh?
To completely disregard the eligibility certificate issued by the Industries Department. Though the eligibility certificate issued to me by the Industries Department is in place, which guarantees industrial incentives to me. In this regard of the said certificate, that taxes have been levied upon the taxpayer.
Hmm.
Portion 2009,
Huh?
item 9, 6977.
6, 9, yes.
Find the agreement order at 863.
Page
863.
Such a long order.
This is long order, the coming 4 pages. But my prayer would be for upholding the order passed by the appeal commissioner, which is a long order. Also. The reason of it.
No, no, first show me your case as to what has happened initially. How do you ask for this?
If I want to produce the review order, third paragraph, the facts will diverge.
Huh?
The facts will diverge from the third paragraph of the review order.
Okay. Yeah,
This is so and so, giving a holder of eligibility certificate and the consequential authorization certificate issued under the Erstwhile Assam Industrial Sales Tax Concession Scheme 1997, has been claiming industrial exemption prior to coming into force of the act with effect from 1/5/2005. 1/5/2005 is the appointing date for coming into force of Assam Value-Added Tax Act. Previously, AGST Act was there. From 1/5/2005, Assam Value-Added Tax Act. So the eligibility certificate of authorization certificate which has been specifically issued was issued under the AGST regime with a specified time period and a specified monetary limit also. However, on later scrutiny by the department, it was found that the activity of packaging drinking water did not amount to manufacture and hence no industrial exemption or remission was legally admissible in such cases, including the present one. The initial eligibility certificate and the consequential authorization certificate had obviously been granted to the SSC due to some inadvertent mistake of law attributable to the concerned authority. The Commissioner of Taxes also came to issue a notification at the instance of.
clarification.
Sorry,
Clarification.
At the instance of any packaging drinking water manufacturer association, clarifying that no tax benefit under any of the schemes, namely 1997, 2005, and 2005 pipeline units would be available to any packaged drinking water unit. The representative association of such units thereafter filed WPC number 12 of 2009 in the Honorable Guwahati High Court, challenging the clarification issued by the Commissioner of Taxes. The said disposition was finally disposed by the Honorable Court, while its order and judgment dated 9/1/2013, upholding the clarification issued by the Commissioner of Taxes. The apex office, that is the Commissioner office, also issued a direction for making assessment of the packaged drinking water manufacturer in the light of the process for that. The learned assessment, thereafter he issued notices and thereafter he assessed me by levying taxes. I preferred an appeal against the said assessment orders. I emerged successfully in the appeals with the assessment orders were set aside and annulled, and it was directed that benefit be given to me. Against that, the superintendent preferred the revision petition, and in the revision petition, the commissioner has taken a view that since there is a commissioner order and since there is a high court order, I am not eligible for any of the that is going the facts of the case. Now, as soon as we are talking about the
Then what do you say about this repetition, the order passed in the WPC number 12?
Repetition order comes up before the lordship, it is necessary to see that order, which will be in the affidavit in opposition filed by the respondent number 3 lordship.
In the
Affidavit in opposition filed by the respondent number 3 Commissioner of Tax. Page 27.
yes.
Various things to discuss as regards the process, how the packaging was manufactured, what processes are undertaken. After discussing everything, lordship, finally one aspect, it was decided that the process does not tantamount to manufacture. So, accordingly, under the state schemes, concessions would not be available.
Hmm.
But one aspect was left open in paragraph 18, lordship, page 27.
So it won't be a manufacture.
It won't be manufactured. Because after that, they have also amended the
The
definition.
submission that the eligibility once granted cannot be cancelled as a mere change of opinion. The applicability of such has yet to be gone into, whether it is a case of mere change of opinion on the table debatable issue or a case of misstatement or error of law has to be gone into by the concern. If it is held that it was not a case of mere change of opinion on a debatable issue, but the case of a wrong grant of a letter either on account of misstatement of a year or ignoring the appropriate authority may take a decision accordingly. So you mean to say in view of 18, it is the industry department who has to cancel it. And if till it is not done, you are entitled. Yes. Yes, industry department.
There are no proceedings pending against this issue.
So, Lordship, as far as cancellation is concerned, the cancellation hasn't been done. Only thing is that Lordship, that's an issue involved is like whether the industry department will act on the advice of the tax department.
No.
Because tax is
The thing is, why have you granted the eligibility certificate? You have granted the eligibility.
No, we have granted the eligibility certificate under a separate set of rules. When initially the company started, commercial production happened, then this eligibility certificate was given. Then there was a separate set of exemption rules were there. Then later on 2005 rules came in, that is GST rules came in. So under that scheme, there was a definition given where this manufacturer is specifically defined there. So under that scheme, when they have come for
No, first time, let us assume. Where is the eligibility certificate?
2001 initially.
2001,
Where? Yeah, annexure page 24. Certified that BN Industries so-and-so is granted eligibility for claiming incentives under the industrial policy. So-and-so. Date of commencement 2001. Sales tax exemption on the sales of finished products. On purchase of raw materials for a period of 7 years, subject to a maximum of so-and-so. Packaged drinking water, PET bottles, PET jars.
filling of the water.
Certificate of authorization is granted so-and-so, no tax shall be levied. Now, what has happened to the certificate of authorization? That has been cancelled.
It is in place.
That has not been cancelled.
In the changeover scheme, Lordship, when the transition.
Is undertaking the manufacture of the finished product specified in table below at her industrial situated at the sum is granted the certificate. No tax shall be levied. This is done under what scheme? Where the scheme?
Lordship, the EC was issued under industrial policy 1997.
Where is it? Mr. Saraf, you know it very well that this court does not adjourn it unless it is a situation like the earlier case where this court was about to demolish the building. For you, 10-15 lakhs this way or 10-15 crores doesn't make sense. But that, for that matter, it doesn't.
Lordship, what would be the regulatory consider in this case, Lordship? Is when the changeover took place from HGST to HGST. For the HGST regime that EC was in place, it was issued by the industry department. The authorization certificate is in place, it was issued by the sales department. As soon as that regime came in, there was a scheme which was given 2005 tax revision scheme for all those industries who were enjoying concessions in the earlier regime. Under section 109, because 2005 scheme was rolled out. And that scheme says all those users who were enjoying the concessions in the earlier regime, they would enjoy the same concessions. In the
We are concerned with which period?
We are concerned from 1/5/2005
So as per the new one.
as per the new.
So as per the new one, what happens to the eligibility certificate? It continues to be issued by the industry department. This is being done under what provision? This is given under the Assam Sales Tax Concession Scheme 1997. Let us weigh the scheme. When it is a case of exemption or benefit, it has to be in your favor. The liberal interpretation does not apply in your favor. There are many judgments against you, what you are submitting. Yes, where is it?
Specifies the eligibility certificate, there is a negative you said the last page. That is really what is not in the.
Eligibility. All industries except those in Schedule 1 shall be entitled to assistance under the. No, that is okay. Incentives and aids shall be available to eligible units in the private sector, so and so all new units as well as so and so shall be eligible for 1993. No, but what is required? How do you get an eligibility?
State level committee. In the state level committee, representative of the industry department.
Definition of eligibility criteria, period of existing package initiative and shall remain in operation for 5 years or till such time may. Means new units set up on or after existing units undergoing diversification on the soil.
Those units who are set up after 1st April.
No, this is setting up. No, this is setting up, understood. But setting up for what? Where is it? If I have a unit out there, if I have my house, would it do?
No, but the industrial policy does not say manufacturer.
So that is why if the manufacturer is not there, yes, finished products. Finished products means and includes the item manufactured by the eligible units as considered under the project scheme approved by the concerned term lending agency and or by implementing agency together with the byproduct scrap which may get generated as incidental to and during the course. Now the benefit is given only to those persons having finished products. Huh?
Finished product is with the manufacturing process.
Where is that finished product?
I mean, let's say that 2003, the value-added tax, under the value-added tax, the state government has come up with the Assam Industries Tax Revision Scheme.
Where is that?
Under the scheme, there is definition of manufacturing.
No, we are concerned with after 2007, 2003.
2005 scheme. So 2005 scheme specifically defines manufacturing.
But the scheme is in place before 1/2005, we will also be concerned with lordship because I was issued in those regimes.
Maybe,
And the change
but
was-
then it is continued till when?
There is a specified period in the EC itself, lordship page 24.
Page 24. The period is from
The period lordship is in page 25 bottom. Sales tax and-
date of commencement of commercial production, 24/2001. And the period will be till 19/4/2008.
This is the.
Sales tax exemption on sale of finished products.
Lord.
So finished products has to be on the basis of manufacture. Yes,
In the AGST regime, the manufacturer also included production.
Hmm?
In the sense that AGST regime, it also included production, not only manufacture. And the manufacturer was a broader definition in AGST regime. In VAT regime, it has been narrowed down. And in VAT regime, also it was.
we are concerned with which one? AGST or the VAT?
That is. But the changeover and title scheme is a VAT.
So you are saying that the benefit which you have accrued on the basis of the AGST regime shall be continued for the VAT regime. But then also for both, there has to be a finished product. Your benefit, what is your benefit? Sales tax exemption on sale of finished products. That's your benefit. But to become a finished product, don't you think a manufacturer is required?
Manufacturer has to be examined in the light of the definitions of the earlier regime, as well as of the new regime.
No. It has to be either of it. It has to be either prior to the VAT regime coming in or VAT regime after. Or it may be for one, either as per the 93.
Actually, by what issue do you see prior to that?
So under such circumstances, but whatever may be, it will has to be a manufacturer has to be as per the for coming into existence of a finished product.
For that, any industry who seek an AC in the new regime, for that it will be reviewing definition will be applicable. But those whose rights stand crystallized earlier,
So what right do you have? You have to come up with a finished product. If they don't consider it to be a finished product, how do you get the benefit?
I have a right with the entire process that I do to the product, but I expect what from the movements.
No, that has been held by the division bench out here not to be a manufacturer.
Already the division bench has decided that bottling plant,
Would not be manufactured. So that is over. That I can't touch it. But the only question here is, therefore, that if it is not a finished product, you get the exemption. Because the exemption is, as per the eligibility certificate, sales tax exemption on the sale of finished products. But can you say it to be finished product if it is not a manufacturer? How?
Something is produced and not manufactured. It will be the
Huh?
finished product. Something may be produced and may not be manufactured.
Yeah, the finished product has been defined out here.
Sales manufacturing process has to go to.
Finished products means and includes the item manufactured by the eligible unit. So it has to be in the.
Documentation 1997.
Hmm.
AGS manufactured a finished product. I am covered under.
So you are not covered under this. Then how can you have both? Either it has to be, if you are claiming a benefit under the industrial policy, it has to be as per the industrial policy act.
But if the industrial policy does not define manufacture, then we have to see that who defines manufacture.
But what has been defined, what has been accepted, but the division bench has already held that that is not a manufacturer.
But that aspect to those industries who have already obtained the EC and the authorization certificates, that aspect has been consciously left open by the court.
That is another thing. That is another argument which we'll consider. But this is not what you are saying now. The first question, therefore, is to whether it is a manufacturer. It is not a manufacturer.
If the entire kind of argument before the appeal commissioner, as well as before this state, pleaded case in this rate, is that irrespective of the process being manufactured, I am entitled to the.
How?
Because of that, the eligibility certificate which are issued.
Eligibility certificate has only given you the benefit under the for sales tax exemption for finished products. Finished product says it to be a manufacturer.
Again, the public tax conditions in 1997, there is a prescribed procedure for issuance of eligibility certificate. There is a prescribed procedure for cancellation of eligibility certificate. No such process has been used. And the state level committee consisting of both the departments have recommended issuance.
No, but if the eligibility certificate says to be a finished product, let's assume to be a finished product they are giving. In fact, the sales tax authorities are also given this packaged drinking water to be a finished product as per the annexure A1, page 26. So this has been given. Huh? That is the most important thing for your purpose. When the sales tax authority have duly done so.
It also lists the finished product.
Ah.
After considering the entire process, the open and clear issue.
That is what I'm saying, and this has not been cancelled by them. So if this is not cancelled, would you not be entitled to?
I would be entitled.
And where is the sales tax concession scheme later on remission scheme? We vacate the interim order. Not satisfied.
If there is advice of Supreme Court of the effect,
Go to Supreme Court then.
if
the 2005 scheme, I have not studied in 2005.
Go to Supreme Court. Then only the interim order has to be vacated if you are not ready to. So here we have the
Not should be considered clause 4 and clause 4 of the university, not 2005. Tax remission scheme 2005.
Industries Sales Tax Concession Scheme. This is the scheme.
Possibility to contain prescribed possibility for expense of.
Eligibility B. One so. Provided further the following categories of industry shall not be eligible for any benefit. Purpose of personal capital investment. List of sales, 7 years subject to a maximum of 1/50% of the human, medium and large. 7 years. Procedure for applying SSA and definition of industry employed and the industry shall be deemed to have complied with the criteria of the industry provided it is improved to 80%. Period of validity of the considering the shouldn't be the solution be for the period of 7 years and take much production of a daily to the world. Or 7 years to the take of millions to the production company. When you look at the period of 7 years, that's 10 years. Others may go, huh? How many years you have issued that authorization certificate? 1 year. It can be so 7 years.
Up to 24,2001 to 19,2008.
How is it possible? In view of the Assam Industry Sales Tax Concession Scheme 1997, you see, the certificate of authorization shall remain valid for a year only. That is up to the end of the financial year and thereafter shall be renewed after examination of the annual return for each financial year for a fraction of the financial year till the eligible unit reaches the maximum permissible limit of sales tax exemption as specified under so and so. The concerned assessing officer shall examine the return furnished in so and so by the eligible unit and pass necessary orders as and when the unit reaches the maximum limit of sales tax exemption. Withdrawing of the certificate with intimation to the authority granting eligible besides taking action.
Certificate of authorization.
Yes, yes.
What's the eligibility certificate?
No, eligibility we consider, but the authorization.
The authorization, if it is issued after issuance of the eligibility certificate, it is issued by the sales tax department. So concession scheme says that it has to be issued each year after verification of the returns, whatever the monetary limit.
So it can be for 7 years.
No, but also it can be issued for 7 years.
Huh?
It will be mentioned in the certificate itself that it has been issued for 7 years.
Maybe, but that is not the mandate of the scheme.
It is so because there are no such officers who can continuously scrutinize the return.
That is a different thing. Are you saying that if there is no officers out there, you can go against the scheme? Can you?
But that is how it was continuously done.
No, that is happening, it is good, but it is well, but till you get caught. Every year it has to be renewed. Anyways, huh?
I was issued two eligibility certificates, subsequently I have expanded, diversified.
Under this scheme, the eligibility certificate is granted to an industrial unit which fulfill all the eligibility in terms with the scheme, and this eligibility certificate is for the purpose of grant of a certificate of authorization to enable the industrial unit to enjoy the benefit of sales tax exemption in terms of violation of any of the conditions of the eligibility or information in the basis of financial being found false at any time after the issuing or failure of the comply with the laid down in the certificate of the qualification of the claim in the Yes, what do you say about the 2003 Act? The manufacture?
Before the VAT regime, the GST definition of manufacturing.
Huh? You want the AGST definition? You don't want the VAT?
Under the changeover scheme, I am entitled under that GST definition.
Why?
Because of the changeover scheme, Lordship, there is a section 1094 of that Act, transition provisions.
109?
Four.
Hey, wait a console. Yes,
Section 109 Lordship.
yes.
Registered unit which had been enjoying the benefits of sales tax concession.
A registered dealer who had continued.
Lordship, subsection 4. 109,
Yes, in respect of a registered unit.
which had been enjoying the benefits of sales tax concession under the Assam Industry Sales Tax Concession Scheme 1997 and any other such schemes immediately before the appointed date, and it would have continued to be so eligible for any period which is to end after the appointed date. Had this act not come into force, the government may formulate appropriate scheme in conformity with the provisions of this act to substitute the said scheme for the period commencing on or after the appointed date. So, Lordship, under this section, a scheme was formulated by the state government. This scheme I have. Submitted to the Lordship.
This one.
It is the Assam Industries Tax Commission Scheme. By Lordship.
Okay.
Page number 2, Lordship. Clause 2, it defines eligibility, Lordship.
An industrial unit which
Which
is
is
or
for
results in
commercial production.
before
Before the commencement of the act and was already found eligible for exemption under the Assam Industry Sales Tax Concession Scheme 1997 as per the eligibility criteria of Industrial Policy of Assam 1997 or Industrial Policy of Assam 2003, as the case may be, shall be treated as eligible industrial unit. So it is a mandate, Lordship, shall word has been used. Provided that an industrial unit shall not be eligible for any benefit under this scheme of its own venture or joint venture if it is a public sector undertaking in the province of India. Then there is a negative list, Lordship. I do not stand there in the negative list. Thereafter, Lordship, will see clause 4. How the certificate of entitlement has to be issued under the changeover scheme, Lordship. The eligible industrial unit holding a certificate of authorization issued under the scheme 1997 as on the date of commencement of the act shall make an application in format 1 appended to the scheme to the prescribed authority within 1 month of the commencement of the act, provided that such application may be admitted by the.
And you got the certificate.
Lordship, I have applied. They have kept it pending and they have chosen to assess me rather than deciding on the application.
So they have not given that.
You have refrained from issuing or rejecting both.
So for the period after 1/5/2005, you don't have a certificate of authorization.
For that, Lordship, the clause 4.
Certificate of entitlement is not there.
41B will be there, then, Lordship. 41B. On receipt of the application, the prescribed authority, after satisfying himself that the application is correct and complete in all respects, shall issue the certificate of entitlement in format 2 appended to the scheme in lieu of the certificate of authorization ordinarily within 30 days. Such certificate of entitlement shall be issued for a financial year only. So, Lordship, it is.
There is no deeming provision. There is no deeming provision that if it is not, it will be deemed.
No, there is no deeming provision. But he cannot shrug off his responsibility. He is to decide the application. He has kept it pending. He chooses to still keep it pending and to assess it.
So without a certificate of entitlement for that period, after the remission scheme comes in, would you be still entitled to benefit?
Without a fault on my part.
No, then in that case, the question would be, would you be entitled to if you are not a manufacturer now?
Yes, Lordship, because if I was eligible under, it says so, clause 2 defines eligibility, if I was earlier eligible, I am still eligible. for the
Understood.
remaining period.
The eligibility certificate which was issued by the industries department is on the basis that you are manufacturing. This item as of now is not manufacturing. This is the finding of a division bench.
And prospective and retrospective information.
What is the prospective retrospective?
The day on which the minister had issued the clarification. From that day itself, it might take effect,
No,
that it might not take effect.
clarification. That is why I use the word clarification, not notification. The moment it is a clarification, it goes back, it is explaining to what has been already mentioned. That is the law.
The clarification was issued under section 105. If your worship will again please reduce section 105.
The clarification where happened under the VAT Act.
105.
Yes.
The worship will see 105 subsection 4.
Hmm.
No decision of the commissioner under this section shall affect the validity or operation of any order passed earlier by any prescribed authority, affiliate tribunal or any court. So once they have issued the certificate of authorization, it does not get affected.
Mr. Sarah, are you saying that the prescribed authority, appellate authority will include the industry department?
So include order has been passed by the sales tax department. Once they have issued the authorization certificate, and once thereafter they have made that it has.
First of all, your authorization certificate should be every year. That is the mandate of the scheme. The scheme says every year. Although that the superintendent of excise or in Texas have chosen to give it for 7 or 8 years, that's a different thing. But when the scheme says every year, so it has to be every year. Now, we are not concerned prior to the 2005. We are not concerned. Now, we are concerned after. Now, this clarification has been made by the commissioner, holding that this water shall not be come within the word of manufacture. And this has been upheld by the division bench. So this water, therefore, would not come. Okay. Now you are saying, that by virtue of the text, you are yet to receive the certificate of entitlement in terms with the remission scheme. You have not got it. So without the certificate of entitlement, can you be given the benefit on the deeming provision?
Without the certificate of decision on my application for certificate of entitlement, I may not be assessed lordship.
Huh?
I cannot be assessed lordship. They can reject it. You will not get it. Then they will reject, then they will assess it to the full turnover. But they have to take a decision on my application. I have filed it in time. They cannot keep it pending also.
So you mean to say there cannot be an assessment being made? Now what will happen to the period thereafter? The limitation on the assessment.
They will either accept my application for entitlement or they will reject my application for entitlement, which the revision scheme does not permit. Except if it is complete and correct in all aspects, it shall issue a certificate of entitlement.
No, he shall, what did it say?
Lordship, it says,
Appended to the so in the lieu of years, such certificate shall be issued for a financial year only. Shall issue a certificate of a year in the. Now, but this is dependent upon such after satisfying himself that the applicant is correct and complete and shall issue. So
Yeah.
when did the clarification come?
30/9/2008. 30th September 2008
By?
by the commission.
He came later on. And when did you file your application?
It was filed 1/5/2015, so I filed it 2005 itself. It is attached with the notification. My application is attached with the notification.
Now, what was the challenge being made? As per that scheme, the scheme which was challenged as regards that circular. The circular was challenged, no?
Lordship, it was whether the process of tantamount to manufacture or not, like
Hmm?
whether the process tantamount to manufacture.
Transformation of what was challenged every year has we had one pathway on an application. With the transformation of non-commercial underground raw water into package we have to manufacture as defined in the section 30. The commission on the manufacture was and your period ends in 2008.
And my first eligibility certificate gives me period in September 2008. There is again an eligibility certificate at page 27 of my application option,
This gives still,
which is till 2011.
and that there also you have issued for a certificate of entitlement.
Has also been-
Huh?
Certificate of entitlement has been applied at page 31 option of the REIT petition,
No, that I have seen it.
page 31. So in the implement judgment, any package drinking water association, the para 18 that I pointed out, I thought hold of this another judgment, which was with the same bench for that's leading in the leading category. What if it says that there is no misrepresentation on my part? So if I was eligible earlier, I will be entitled. Perhaps this is the reason why that paragraph of that.
But are you filing a writ petition for the purpose of issuance of the eligible certificate of entitlement?
No, Lordship. No, Lordship. They have assessed it if it is pending.
No, understood. But unless you have issued the certificate of entitlement, would you be entitled to?
If you have to assess in the appropriate manner, Lordship, you will have to decide. And the appeal commissioner, while deciding the appeal, he has held that it was a faulty order of assessment without deciding the application for entitlement, assessments were completed. So he had directed the superintendent of taxes that in terms of clause 2 and clause 4 of the tax commission scheme 2005, first you decide the application for entitlement and then you proceed for assessment. It is the verdict of the appeal commission. This is very reasoned order of Lordship by discussing the entire law.
Yes, Mr. Chaudhary. Yeah. Without going into the question of manufacturer or not, you have to take a call on that application. Why haven't you taken that? Whether he's entitled or not, it's a different aspect. But you have to take a call on that application. And if you are not taking a call, can you now assess on one hand, then later on what will happen? If you assess, if you decide, but can you keep this matter pending when the mandate is to do it You have to do it, reject it, give it to them.
Aspect, as to whether, certificate, the application for renewal of certificate of assignment was.
No, for issuance of a certificate, it is not renewal.
uh,
That has already come to an end. Now you see, this is for the period prior to the clarification. It is not a clarification which you may use, whether it's a clarification or a notification, it's a different thing, different thing. It is not known, although the impugn order says to be a clarification, I don't know.
If process, once they did that, clarification, that process.
Show it to me. So under such circumstances, why you are not taking a decision as to whether he is entitled to the settlement, certificate of entitlement or not? That's all. Unless going into all complications, decide. And if it is so, he is entitled, give it. If he is not, better then, that is not the issue anywhere.
Yes, but that was not the, our, so, and that was not the, cited.
No. Only thing is that it's a simple. It boils down to only a simple thing. Now, this is an amount which we have imposed. He says that I'm entitled to. He had filed an application for entitlement. Because after the coming of the VAT regime, the tax remission scheme has come in. So he can't get the benefit of the tax regime scheme unless you give the certificate of entitlement. He filed for the certificate of entitlement. That certificate of entitlement have not been issued. And without issuing on one hand, which he is entitled to or not, that is a different thing. But you have to take a decision. You can't keep it for all. Until now, you have not done it. How can you make the assessment? And this is what has been handled by the appellate authority. Giving you the liberty to make. But you have to first decide the certificate of entitlement. Just, we'll take it up on Thursday. Just look into it, only one thing, as to whether this will in any manner affect your limitation for assessment. Because these are very own matters. The periods will be there. So would it affect your limitation? Then this court has to mold the relief in accordingly. Because if you are entitled to amount for this technicality, he should not get the benefit for that. But only to that effect, you have to look at it. The matter is unnecessarily, it is made very complicated, but it is not so. It is the simple question is whether it is a case of entitlement, whether he is entitled to the certificate of entitlement. Whether this order is retrospective or prospective. These are aspects which have to be taken into consideration by the superintendent, whoever does it. Who does it?
The superintendent.
Superintendent, he has to take a decision on that.
So, as far as industry department as well, accident department is also concerned. It's caretaken by the department is that eligibility certificate itself, the initial eligibility itself was erroneously. So it has come to our office, the department later.
Why haven't you cancelled it?
Lordship, that has been stated in the agreement. That-
Why you have not cancelled it? Why haven't you
Because
cancelled it?
there was stay order was there, that matter was going on in the court, that's why the stay doesn't. The stand taken by the department is that under the earlier regime also,
that eligibility certificate that has been issued, it was mistakenly erroneous.
Why?
So that is because there was some error happened, and when they came up for the second time, when they came up for the entitlement certificate.
Okay, we'll have you hear it on Thursday. Why? Mr. Mr. Saraf, I'm not concerned whether Mr. Chaudhary comes or not. I'm not concerned with all this. For me, senior counsel doesn't matter. So I don't give any accommodation for senior counsel.
Lordship, I have a personal request.
Why?
Because tomorrow, Lordship, I'm doing some treatment, Lordship, people from your nurse. Some food problem is going on, so Lordship, I have a recommend the doctor tomorrow for camp. So Thursday, Lordship, when I pick up, maybe next week or Tuesday. I have personal problems, I have honest problem. It's a personal problem, but I have a recommend in the evening, so it will be difficult.
Also, immediate accept 28.
Okay, the matter upon being heard at length. This court would hear the learned counsel for the industries department and the finance and taxation department again on 26th of September 2023. The matter be listed at the top of the list. Huh? What is that matter about? Huh? Why is that matter coming before this court? That's the matter where Mr. Bhuiya is there. Oh, you know, Mr. I don't fix matters. I don't fix dates for Mr. Bhuiya, you know that. I don't fix dates for Mr. Bhuiya. He only said not to fix dates. Remember that day we were sitting on that side.
It's the industrial department certificate in some states that like for 7 years.
Huh?
That 7-year period process.
Ah.
The industrial department certificate in some states about the 7 years. Instead of as per the policy, it has to be renewed every year. But the industrial department certificate is certificate that states about 7 years.
No, that is different.
Yes, and on that this is floated the authorization.
No, he couldn't have given it.
Yes, that was a mistake.
You know, he, as because the industries department, he is entitled for a benefit of 7 years. But for you, you are to look every year.
Yes, okay, that's a.
Don't worry with it.
Exhibit is actually there for 7 years. I don't think